Good morning. Good morning, my friends. Thanks so much for coming to hang out with me for a part of your Tuesday, October 15th of 2024. It's been a while since we've done a show on Carly Gregg, and the papers are in. The opposition papers to the motion for the new trial are in. I'd like to go over them with you today. Take a look. I think last time that I had Bridget Todd on the channel, we went over her motion for a new trial. So now we have the opposition papers to look at. 51 pages they put in opposition. In their opposition, it is 51 pages long. We'll go through the most important parts of it together. And then there's going to be a live interview on a local news channel in Mississippi of Catherine Newman, the prosecutor. And I thought that would be something really interesting to watch together. That's going to come on a little bit later, around 1 o'clock. So I thought we could watch that together when we're done with the papers, because that'll be fun. How is everyone? How is everyone today? Oh, thank you so much, Lori Life 360 for the win, for being with me for 6 months and for thinking that this is the best place for you to be in the morning. I don't know what time zone you're in, but we have viewers across the pond. This is a case of worldwide interest, really, because there are a lot of viewers of mine and elsewhere who live outside the U.S. who are very confused about what's going on here and very concerned that in the U.S. we are willing to try our children as adults and then give them the possibility of life without the possibility of parole as a sentence. And that is exactly what happened in the Carly Gregg case in Mississippi. She was 14 years old when she killed her mother all the way back in March of 2024, and was tried and convicted within 6 months of the crime. For those of you who are not familiar with it, Carly Gregg was 14 years old. She had a history of mental illness. She also had a genetic history of mental illness on both sides of her family. Her father, biological father, is a diagnosed schizophrenic who was abusive, according to accounts. And she and her mom had to flee the bio dad when she was about 4. And she had a sister who was about a year old. And then her sister died tragically at 18 months old of a genetic disorder. And there are reports that Carly had also been severely abused as a child and that she was forced to visit this biological dad despite his drug addiction issues and his mental health issues, and that he was free about doing drugs in front of Carly, offering her such drugs as hallucinogens when she was just a little child. And there also was a history, apparently, of her mother being bipolar. And one day, the defense says that Carly snapped. She went into her mother's bedroom and took a loaded .357 Magnum, which was in plain view, and walked into her mother's bedroom very calmly. I think it was, into her. She went and got the gun from her mother's bedroom, walked into her own bedroom where her mother was, and shot her 3 times. As her mother was dying, she walked back into the kitchen, hiding the gun behind her back, sat on a stool, and apparently very calmly, or as the defense argues, in the midst of a disassociative episode, texted her stepfather from her mother's phone, asked him when he would be coming home. Then she called a friend to come over to see her mother's body. She laid in wait, according to the prosecution, for her stepfather. And when he arrived back home, she attempted to kill him, according to their theory. And he survived. And he has been behind her this entire time, as have her maternal grandparents and the entire extended family. They wanted her, obviously, to get the help that she needs, or that they think that she needs. And yet, the jury tried her, convicted her on all counts, and she was sentenced. And then the jury got to decide her sentence too, which is unusual, to life in prison without parole. She's currently being held in a youth facility until she's 18, at which point she will be transferred to an adult facility. And here we are. I've had Bridget Todd, her attorney, on my channel twice to talk to us, to answer your questions. to bring awareness to the case for mental health reasons. Yep. Exactly. Thank you, Unlock. Trying to bring awareness to mental health, trying to be bring awareness to the fact that maybe we should not be so quick to lock up our children and think that there's no chance of rehabilitation. Now she's on some pretty serious antipsychotic medication while she's in prison. And she has made dramatic strides, I believe. She's on like the highest dose of Abilify, which is an antipsychotic medication given to schizophrenics. And it's an adult dose, and she seems to be doing much, much better. She's not joining us today, Bridget. But I'm going to go over the opposition papers. I thought that would be boring for her to do because she has she's already read them, obviously, and we're waiting. She's waiting for a hearing date. As soon as we have the hearing date on the motion, we'll cover that live as we normally do. And I absolutely put the link below if you'd like to help contribute to the cost of CARLY's appeal, because as you may or may not know, Bridget Todd and her co-counsel, Kevin Camp, took on this case for free. They're doing it pro bono. CARLY did not qualify for a public defender in Mississippi, which is kind of crazy because she's 15 years old, but apparently because her extended family has assets, she was not eligible for a public defender. And Bridget Todd heard about this case and decided that she was going to do something about it, and she took the case for free. So they have been representing her for free. And it's very expensive, as you know, for appeals and experts and things like that. In fact, we looked at Dr. Pickett's bill last time you were here. He was the expert for the state. And can you remember what his bill was? I think it was something like, I don't know, $52,000 or something. Whereas a typical expert would be maybe around 10. So he rendered like an 86-page report or something crazy. Hi, Vice. A few minutes late, says I'm 100% against trying any child as an adult, regardless of heinous allegations of charge. I think we've got a real mental health issue in this country, and we need to address that. I don't think personally locking up a child and throwing away the key and saying she's absolutely never has any chance for rehabilitation ever is it's a sad state of affairs for our country. And people outside of our country don't understand that. They're like, how could you do that? We don't do that in our country. So there's that. I have not seen her wish list. I heard that there is one. I do not have the link to it. Bridget was going to send it to me, but I don't know what happened. How does a child not qualify? She doesn't have a job. This is unfair. I know. And that was also one of the arguments in the motion for a new trial, is that in Mississippi, you have to be 21 to serve on a jury, which is far different from a lot of other states where you only need to be 18. And the argument was, listen, she's never going to be able to be tried by a jury of her peers because they all have to be 21 or older, which I think is one of the less strong arguments in the motion for a new trial. But we'll take a look at that. Here's something that kind of, I don't know if you guys have seen this, but I want to play this for you because it's kind of, I found this to be a bit Michael Morrissey-ish. You know. This is his name is Bubba Bramlett. He's the district attorney for Rankin County, Mississippi. And this was his statement that he gave after the verdict of CARLY Gregg. Listen to this.
CARLY Gregg is evil. And that's not easy to say, but the truth of the matter is sometimes evil comes in young packages, small packages. And this is one of those cases. She's fit to go to prison for the rest of her life. You hate that. She's 15 years old. But that's exactly where she belongs. I felt like her defense threw a Hail Mary trying to say that she was insane. CARLY Gregg and the word insanity should never be used in the same sentence. In Mississippi, you're insane if you don't know right from wrong. And she knew what she was doing was wrong when she killed her mother. And she knew all the evidence, not most of it, all the evidence.
You heard the name Kevin Gregg a lot during the
CARLY Gregg. What did he say? CARLY Gregg and insanity should never be used in the same sense. I mean, I have to listen to it again. CARLY Gregg is evil. CARLY Gregg is evil. So I guess in Mississippi, in Rankin County anyway, their district attorney believes that CARLY Gregg is evil. She's got no chance in hell. They threw a Hail Mary by trying to say that she was insane because CARLY, Gregg, and insanity should never be in the same sentence. Is this the district attorney that you want in your county if you're a parent? I got to listen to this again. It's only 54 seconds. So let's hear this again.
CARLY Gregg is evil. And that's not easy to say, but the truth of the matter is sometimes evil comes in young packages, small packages. And this is
Sometimes evil comes in young packages, small packages. It's not easy to say. Really? Did you rehearse this?
one of those cases. She's supposed to go to prison for the rest of her life. You hate that. She's 15 years old. But that's exactly where she belongs. I felt like her defense threw a Hail Mary trying to say that she was insane. CARLY Gregg and the word insanity should never be used in the same sentence. In Mississippi, you're insane.
CARLY Gregg and the word insanity should never be used in the same sentence. Even though she may have been, beaten as a child, forced to flee, watched her mother be beaten as a child, had her younger sister die tragically when she was 4 and her sister was 18 months old. And, CARLY Gregg and insanity should not even, I haven't even touched upon the fact that CARLY Gregg was a cutter. She was on psychiatric meds, and that they switched up her meds within days of this event, where she had quit her Zoloft cold turkey against medical advice. I mean, she's 14 years old. And then she was switched on to Lexapro. And it has been shown that there can be crazy side effects from these medications that we are pumping into our children, sir, counselor. So CARLY Gregg and insanity should never be used in the same sentence. Okay. In Mississippi, you're what? What are you in Mississippi? Let's hear what he's got to say.
And the word insanity should never be used in the same sentence. In Mississippi, you're insane if you don't know right from wrong. And she knew what she was doing was wrong when she killed her mother.
You're not inside of her head. That's the problem. You're not inside of her head. You don't know. I mean, the way they just, this makes me mad. I didn't mean to start off on in a mad rant this morning, but the more I listen to this man, the more it is upsetting me, Bubba.
And she knew all the evidence, not most of it, all the evidence.
You heard the name Kevin Gregg.
Okay. What do you guys think about that? Am I overreacting to that? Is that the way that a district attorney of a county should behave? Kimberly says prison is the last place she needs to be. Yeah, she should have been weaned off properly, right? She was supposed to wean off of that before she starting the Lexapro. Vice says the med change is paramount. Christine says, that's shocking to speak of a child that has so many mental health problems. Listen to this. The sober hipster says, when I came off of Fexer, cold turkey in my 20s, I thought I was losing my mind. Literally called my mom to come be with me. She was 14 years old. 14 years old. And there was evidence that she had been hearing voices since she was like 4 or 5. And if you have something like schizophrenia and you're put on those other kind of medications, that is another factor that needs to be taken into account. I find it crazy. Right, little cupcake. In Mississippi, you're insane if you don't know right from wrong. What could possibly go wrong? Thank you. Thanks, Kale. Says I relate to CARLY, and to hear this, I'm outraged. I mean, this is who's representing them in Rankin County. This is their top dog. Thanks for becoming your super sticker, Mrs. Bucket, and Kale. Thanks for becoming a new member. True Crime Addict. Thanks for hanging out with me for 4 months. Says I love being in this community. I changed my mind after watching the trial and learning so much from me. Oh, thank you. CARLY needs to be in a mental hospital. And I think a lot of people wanted to hear her story. And her attorney, Bridget Todd, told us that she could not subject her to cross-examination by Catherine Newman, that she didn't think that she'd be able to handle it. And we're going to watch a live interview with Catherine Newman at 1:00 together. And we're going to see what we think if CARLY would have been able to withstand possible cross-examination by Catherine Newman. You guys remember her at the trial, right? Let me pull up. Remember last time we were together, we watched an interview that CARLY's bio dad, Kevin Gregg, did with a news channel. And then part of the argument for the new trial was that Kevin Gregg told the media that CARLY went to equestrian therapy or equine therapy when she was very young because she was hearing voices. And once Bridget said that, either on my show or somewhere else, the news channel said, oh, no, he didn't say that. And they got really, really defensive. So they released the unedited version of that interview. So I think that we should watch that together and see what he's got to say, because I found it really interesting. Why is it buffering? Okay, here it is. This is Kevin Gregg, and this is his interview with WLBT3 on your side. And they released this September 30th, so it was about 2 weeks ago.
All right, well, we'll just talk like.
Wait a second. Hold on. We were married in 2025. Yeah, he's got no sense of time, it seems. Yeah, that's exactly what it says. Hold on. Yeah, you loved her so much that you gave her dangerous drugs and bragged about, eating so many mushrooms one time. It was quite a feat. Yeah, he doesn't even know which way is up. You can understand now why they couldn't call him at trial. Well, first of all, he was avoiding service. The guy is like a very good dodger of service of process. So even during the family court cases, they could not have him served because the process server could never find him. And also he's a loose cannon. Just listen to this interview. So when we saw the original, the edited interview, obviously that they released on the news, you did not see this reporter or this interviewer interviewing him. It says her name is Morgan Harris. It was just really, the focus was on him. And obviously a lot of this was edited out, and you'll see why. Yeah, it's called parental alienation. But sometimes, one parent needs to get the child away from the other parent if, say, perhaps, there's an addiction problem or a drug problem or a wife beating, child beating problem. Not saying that was in your case, but sometimes it is necessary for the other parent to do whatever they can legally to prevent that toxic person from having any contact with a child. Did you just hear? I'm not going to make a joke. Oh, but I was going to say, and then he says it. Today I'm snorting oxycodone and sheetrock. Like, you can tell that he's bat crazy. He's ducking crazy. In my opinion, something's wrong. Oh, I just noticed the title of my stream is totally spelled wrong. Okay, I gotta fix it. He hadn't seen her for a year and a half. The last time we saw her was September 2022, and this happened in March of 2024. He was out of there. Right. He says he's bipolar 3, but when he comes to CARLY, it's crickets. Thanks. Mother O's and Fall Star is going to get us all in really great shape. One push-up for every time he gives an answer that feels weird. Man.
Sure.
I just screwed that up. Here's talking about the video. He knew she was guilty. Very guilty.
It's like, who are you? I don't even know you. It was devastating.
That's what I was going to ask. So
Did you ever know?
That was
Did you ever know her though? Did you ever know her? If you were high all the time?
the premise of this case. Was CARLY mentally ill?
CARLY was suicidal between the ages of 7, 8, and 8. And you don't think that by the time she's 14, which is twice as long, and you're claiming now that Ashley was mentally abusing CARLY at a very young age. Listen to this. I mean, this helps Carly's case.
Gregg had
Crossed by my esquire in court. He's leaning in now like he's getting real serious. Hang on a second. I don't know who Annette Bryant is. I don't remember her name during the trial at all. Does anybody? Hold on. And he's blaming the victim and saying that she was a horrible mother. And yet, by the same token, didn't affect Carly at all if what you're saying is true.
there was
Did he terrorize her with religion? I don't know anything, and I don't pretend to know anything about the Jehovah's Witness faith, but I've heard from some people who were raised in that faith. When they were children, they were shown some very, very, very disturbing things. I don't know if there's anybody here who can confirm or deny that, but it just popped into my head when he started talking about that. Permanent psychosis, like, this guy should have testified at the trial, because perhaps the jury would have gotten a glimpse into what her genetic makeup is. And he's also saying that Ashley was crazy too. So what chance did this child have? Listen to this, trying to balance my crazy with Carly's crazy. Something about a bottle to kill herself and drank the whole thing, and she had to have her stomach pumped. Hold on a second. He's talking about Ashley. This is the stuff that Bridget was telling us they were trying to get in about her mom. They wouldn't let it in. The judge wouldn't let it in. Listen.
what Ashley told me. You know, her new husband, her high school sweetheart left her. It made her super.
Hope she finds God. That's his answer. Hope she finds God. Interesting. Thoughts, concerns, comments. South African Uma says, surely they need all the info on Carly. Why would they not let her grandmother testify? They need the truth. We're going to go to those papers in a second, and I'm going to show them to you. Oh, thanks, Lori, for the 20. Dang, I was playing a game. I was in the bonus round and couldn't get back here fast enough about the 2025, 2026 dates. Thank goodness there were others in the chat that heard it. Oh my God, that poor girl. Thank you, Lori, so much for your 20. And she's like Texas. Thank you so much for gifting 5 memberships. That is so very kind and generous on this Tuesday morning. It's afternoon now. Thank you so much. Some guy with cancer. Thank you for the 5. I'm on a lunch break and I see this clown. It's all poor me, right? Poor me, poor me. Hi, Helene. Always look forward to your insight and coverage. Thank you for hanging out with me for 4 months. Crow Retta, I wanted to know if he paid child support regularly. No, he's in arrears, and that is why he can't be found for service of process. So no, he did not. And then this person, I don't know, Sarah, if this is one of the boarding passes you already handed out, says, couch juror says, oh, my bleeding heart. Do you people feel the same way for the teen school shooter? These 15-year-olds get life. Where's the outcry for that? I cry out about a lot of things. I haven't handled any of those cases, but I absolutely, positively think that Ethan Crumbley did have severe mental illness. I also think the school knew about it and they didn't tell the parents. I also think that the school had their backpack in their hands that had a loaded gun in it. So, there's a lot of issues there. Ethan Crumbley, I think that young man from Georgia also has some severe mental health issues. So I guess you're new to my channel because I cry out about a lot of things. I just think that if we're going to be a society that's going to lock up our children and throw away the key, we have a lot of problems, and we're focusing on a lot of the wrong things. It's my opinion, sticking to it. So I don't know if you're still here, but what an odd comment. Kimmy, thanks for the 5. Manipulation, vitriolic attacks from Kevin. Make no wonder Carly has mental issues. Her brain was so confused. I know, Kimmy, right? Hope you had a nice Thanksgiving. Yesterday was Thanksgiving in Canada. For those of you who celebrate, let's take a look at the picture. Let's take a look at the papers from the state of Mississippi regarding the opposition to the motion. which is 51 pages long. We're going to look at portions of it, some things that you guys wanted to know. One second. Okay, this is the response to the motion for a new trial, or in the alternative, judgment notwithstanding the verdict. I have put the National DV hotline scrolling at the bottom of your screen. In case anybody needs it, please do not hesitate to call 1-800-799-SAFE or 1-800-799-7233. Bice thinks he sees a movie deal down the road. Oh, God. God help us. And yes, Kate, I agree. We can't ignore the mental health of our children. We're pumping medications into them that we don't know the long-term effects of. And in fact, if you remember, the medical providers that treated CARLY testified at her trial. They would not communicate with the defense prior to the trial because they all lawyered up, and their lawyers told them not to talk to the defense. So the defense didn't know what they were going to say. But the medical provider who had been prescribing the antidepressants, I think it was Zoloft and Lexapro, was a nurse practitioner. And, that has its own set of issues, in my opinion. I'm going to be reading now, so I'm not going to be able to look at the chat. So just save your questions if you don't mind. So here comes the state of Mississippi. They're going to, disagree with every single thing that the defense has said. And they're going to give a lot of reasons, a lot of statutory authority for it, and try and back up their positions because their DA thinks that CARLY Gregg is evil. And the words insanity and CARLY Gregg should never, ever, ever be in the same sentence. You heard him. You heard him say that because we watched that at the beginning of the stream. Here's what they say. According to the Mississippi Rules of Criminal Procedure, here are the grounds for a new trial. 1, if required in the interests of justice. 2, if the verdict is contrary to law or the weight of the evidence. 3, if new and material evidence has recently been discovered, which probably would produce a different result at a new trial, and by reasonable diligence, such evidence could not have been discovered sooner. 4, if the jury has received any evidence, papers, or documents not authorized by the court, or the court has admitted illegal testimony or excluded competent and legal testimony. 5, if the jurors, after retiring to deliberate on the verdict, separated without leave of court. 6, if the court has misdirected the jury in a trial, misdirected the jury in a material matter of law, or has failed to instruct the jury on all questions of law necessary for their guidance. Or 7, if for any other reason the defendant has not received a fair and impartial trial. The state says the Rankin County jury got the verdict correct and there were no errors by the court that adversely affected the defendant. She is not entitled to relief under Mississippi Rule of Criminal Procedure 25.1. Then they go on the standard for a new trial, and then they say, motion for a new trial is based on the weight of the evidence and will be disturbed only when the verdict is so contrary to the overwhelming weight of the evidence that to allow it to stand would sanction an unconscionable injustice. Ordering a new trial should be invoked only in exceptional cases in which the evidence preponderates heavily against the verdict. Applying this standard to the case at bar, the defendant's motion for a new trial should be denied. The defense opted for the trial strategy of telling the jurors this was not a case of whodunit. They cannot now claim that the weight of the evidence resulted in the defendant's conviction for the crimes serves an unconscionable justice. Well, I don't really think that's the point because there was a video of her doing it. So, not actually of the actual crime, but we could hear it going on in the background. The standard for a motion notwithstanding the verdict, directed verdict, and peremptory instructions. In a criminal proceeding, motions for a directed verdict and a JNOV challenge the legal sufficiency of the evidence supporting the guilty verdict. And then they go on to say we should not overturn the verdict because the weight of the evidence was there. And I don't really know. I don't think that the court would reverse on these grounds, so I'm going to skip over a lot of it. But they say that this court will reverse only when reasonable and fair-minded jurors could only find the accused not guilty. I mean, there's a reason for, there's an argument for insanity. So let's go to that standard regarding insanity. The McNaughton test for determining insanity is whether the accused knew right from wrong at the time the act was committed. Specifically, the court has held that to prove insanity under McNaughton, it must be proven that at the time of the act, the accused was laboring under such defect of reason from disease of the mind as, one, not to know the nature and quality of the act he was doing, or two, if he did know it, that he did not know that what he was doing was wrong. And that's a case from 1990. The determination of a defendant's sanity under the McNaughton rule is within the province of the jury, and the jury has discretion to accept or reject expert and lay testimony on the subject. A jury's finding on a defendant's sanity will not be reversed if it is supported by substantial evidence. We have held that in insanity defense cases, perhaps more than any other, a jury's verdict ought to be given great respect and deference. And then they say, applying the standard, the jury's verdict and determination of the defendant's sanity should be accepted as it is supported by the substantial evidence. As such, the defendant's motion for a new trial or the jury's verdict to be set aside should be denied. The defendant's argument about not having a jury of her peers is improper and lacks merit. The defendant argues that she was not tried by a jury of her peers. She fails to cite any authority for this argument. This argument is without merit and not supported by the law. In our system of justice, every person charged with a crime is entitled to receive a fair trial before an impartial jury of his peers, citing the Mississippi Constitution. Despite the defendant's assertion that a juror of her peers would be someone of similar age, neither the U.S. Constitution nor the Mississippi Constitution requires that a jury of a defendant's peers be someone of the same or similar age. In fact, our courts have previously held that age is not a protected class in juries. And then they go on to say, defendant did not object to the panel. And then here is the U.S. Constitution, 6th Amendment regarding fair and impartial jury. Reads as follows. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Nothing in this amendment entitles a defendant to a jury made up of individuals who are of a similar age. And then they go on to cite some case law. The Mississippi Supreme Court has held that age is a well-supported race-neutral reason for a peremptory strike. And then here's the Mississippi statute with regard to people who are competent jurors. And I found a lot of parts of this interesting. Every citizen not under the age of 21 years. So you have to be 21 to serve on a jury in Mississippi. Most states are 18. New York is 18. If you come from a state where you have to be 21 to serve on a jury, let me know. Who is either a qualified elector or a resident freeholder of the county for more than 1 year is able to read and write. Okay. So you have to be able to read and write. You have to live there for more than a year. You have to be 21 years old and has not been convicted of an infamous crime. What's the definition of an infamous crime? Or the unlawful sale of intoxicating liquors within a period of 5 years, and who is not a common gambler or habitual drunkard, is a competent juror. How are you going to know who's a habitual drunkard? Is that like one of the questions on the jury form? Are you what is a common gambler? Like, when was this written? This is bizarre. Isn't it a bizarre statute? So if you've been convicted of an infamous crime, not just a felony, like if you're in New York, I think if you're a felon, you can't serve on a jury, a convicted felon. This is An infamous crime. It has to be an infamous crime. Or if you are charged with the unlawful sale of intoxicating liquors within a period of 5 years. Was this written during Prohibition? I'm so confused. Right. Bootleggers. Yeah. Bootleggers, moonshiners. Like, this is how old this statute is. Right? What century did we just teleport? We teleported to Mississippi. Hello, Mississippi. Yeah, bootlegging and moonshining. Seems very archaic, right? No person who is or has been within 12 months the overseer of a public road or road contractor shall, however, be competent to serve as a grand juror. I don't even know what that means. The overseer or of a public road or a road contractor. Yeah, it's a backwater rule straight out of the 1920s, right? The lack of any such qualifications on the part of one or more jurors shall not, however, vitiate an indictment or verdict. Moreover, no talesman or tales juror shall be qualified who has served as such talesman, talesman, or tales juror in the last preceding 2 years, and no juror shall serve on any jury who has served as such for the last preceding 2 years. No juror shall serve who has a case of his own pending in that court, provided there are sufficient qualified jurors in the district and for trial at that term. I mean, that's bizarre. That's like saying if you live here on Long Island and you have a pending case in Nassau County Supreme Court, which practically everyone probably does, that you can't serve as a juror in Nassau Supreme or Suffolk. Like, that's just a bizarre. That is just a bizarre statute. I got to look up what talesman. It's talesman. It says a member of a large pool of persons called for jury duty from which jurors are selected. Meaning, if you have already served. Okay, so if you've been on a jury in the preceding 2 years, you can't serve. Okay. And that's their statute. And then they argue the jury in this matter was made up of qualified electors from Rankin County, Mississippi. No one was excluded based upon race, color, religion, sex, national origin, or economic status. I'm not going to spend too much time on this because I didn't think that this was the strongest argument. But it says here, the right to a jury of one's peers does not entitle him to a jury which includes convicted felons or bootleggers. They're still talking about bootleggers. What? It's crazy, right? Defendant's argument that motive is required is not supported in law or reason. I don't think we need to go through that. And it says here, motive is not included in any of the elements for the crimes the defendant was found guilty. As such, the defendant's argument about lack of motive is without merit. Defendant's claim about the victim saying CARLY was not in her right mind and did not recognize him does not rise to monotonic insanity. And this is about Heath. See which parts I highlighted here. I'll just read this. Among other things, the defendant asserts that there is undisputed evidence at trial of the defendant's mental illness. This is simply not true. In fact, there is absolutely a dispute with regard to the defendant's mental illness. The defendant puts a lot of stock in their argument that the living victim, Heath Smiley, said, quote, CARLY was not in her right mind and did not recognize him at the time of the offense. This statement contradicts all the other evidence wherein the defendant actually texted the victim asking when he would be home, specifically told her friend that she put 3 in her mom and had 3 more waiting for her stepdad. Also, when the defendant asked her friend if she wanted to go outside while she took care of her stepdad. Additionally, based off of the evidence presented at trial, remember, we didn't hear a lot of this because the minor's testimony was not broadcast. So apparently that is what her friend testified to. She asked her friend if she wanted to go outside while she took care of her stepdad. Additionally, based off the evidence presented at trial, the defendant only asked about how her stepdad was after she was taken into custody, indicating she knew she shot him. Furthermore, there was a mountain of evidence at trial regarding the fact the defendant was sane and knew right from wrong at the time of the crimes. However, even if this honorable court was to ignore all the other evidence, Heath saying CARLY was not in her right mind does not meet the McNaughton standard. Our appellate court has found that a strange look on the defendant's face at the time of a shooting was not enough to prove insanity. And that is a case from the year 2000. The state argued prior to trial and during the trial that the defendant's expert, Dr. Andrew Clark, should not have been able to testify in front of the jury, as his testimony was not proper and did not apply the correct McNaughton standard. Specifically, the state argued and continued to assert that Dr. Clark's testimony was nothing more than hypotheses and was more of a diminished capacity argument, which our court does not recognize. However, Dr. Clark did testify that it appeared at times the defendant knew what she was doing at times. This indicates that she was not insane at the time of the crimes. I don't know that that is what that says at all. Just because she appeared at times that she knew what she was doing at times does not indicate she was not disassociating at the time of the crime. Again, assuming you ignore all of the other evidence demonstrating that the defendant knew right from wrong when she texts the victim, texts her friends, FaceTimed her friends, called her friends, told her friends she messed up, told her friend it was too late when they said don't harm anyone else, told her friends not to call 911, hid the gun out of sight of the camera, removed the camera, fled the crime scene, admitted to law enforcement that she was the one who was involved in the shooting, admitted to Dr. Clark and Dr. Giuliano that she had flashbacks of holding and shooting a gun, of the loud gunshots, that she gets queasy thinking about the crimes, among many other facts, and believed Dr. Clark that the defendant had bipolar 2 and schizophrenic symptoms. That does not get you past the second part of McNaughton, which requires someone to not know right from wrong. There are lots of people that have bipolar disorder and or schizophrenia and or anxiety and depression that do not murder people. Well, yeah, that's true, but we're talking about this specific child, right? Rachel B says, I've been a psychologist for 20 years. I've never heard anyone call it that. He must have Googled. Are you talking about bipolar 3? Hi, Truth Art says bipolar 3 is also known as cyclothymic disorder. Yeah, I think that Dr. Berry said that, right? Sadie says the punishment was very harsh for a minor with mental issues. No. Rachel, Dr. Berry says, yep, same Rachel B. Thank you, CJ's mom, 55, for the 5. She loves me. Carly's defense fund is up to 9,200. Let's keep it going. Do we have an address to send email gifts or an Amazon account? I know Bridget has one. I'm going to ask her right now if she can send it to me. Thank you. Thanks for asking, CJ's mom. Barry Ducky, can the interview we just watched with her father be used in Carly's appeal? Thank you. I hope so. I hope it can. I do think that would be helpful to the defense. What do you guys think? Oh, you guys want her Amazon wish list. That is very sweet. Oh, she does have an Amazon wish list. Where is it? Is it on Amazon? Like I want to make sure that we have the correct link. Thank you, Cindy. I agree. We should just make sure that we have the correct link. Yep. The example, Bridget Todd. Thanks, Little Cupcake, for pointing it out. She says, search Carly Gregg's name in Amazon. All right. We just want to make sure it was the right one. Little Cupcake says the example Bridget Todd gave was perfect, right? About like disassociating. Sometimes you drive miles and miles of twists and turns until eventually you realize you mindlessly drove to the wrong destination without incident. Yes. When I get the proper link, I will link it in the video description below. So check back later. Oh, they moved this interview with Catherine Newman to 2 o'clock. How dare they? I'm gonna have to come back and watch it another day. Let's see. Just because a person is schizophrenic does not mean the person is not insane, according to these cases from 2011. And oh, that's a case from 1986. So this the Parker v. State is what they're relying on here. And it says, the court discussed that Parker's testimony of taking prescription drugs for anxiety and depression and a suicide attempt years prior has no apparent relevance to his ability to know right from wrong at the time of the incident. Just because a person is schizophrenic does not mean that a person is McNaughton insane. Nor does Parker's testimony that he does not remember shooting Eric establish McNaughton insanity. Not being able to remember is not the same thing as not being able to distinguish right from wrong. Evidence that the defendant does not remember or was in a blanked out state of mind during the commission of the acts charged is insufficient to raise the issue of insanity. Talk about amnesia, memory loss. Similar to the testimony in Parker, at best, the defendant herein sought to introduce evidence of diminished capacity, a defense that is not recognized under Mississippi law. Defense expert Dr. Andrew Clark also failed to state his testimony was to a reasonable degree of medical certainty during his direct examination. Yeah, but that's okay, because the judge allowed him to clean it up. It's fine. However, the court allowed him to continue to testify. Regardless of whether his testimony was proper or not, the determination of a defendant's sanity under the McNaughton rule is within the province of the jury, and the jury has discretion to accept or reject expert and lay testimony on the subject. A jury's finding on a defendant's sanity will not be reversed if it is supported by substantial evidence. And then they go on to say, we have held that in insanity defense cases, perhaps more than any other, a jury's verdict ought to be given great respect and deference, citing a case from 1986. The jury weighed the credibility of the witnesses and the testimony and determined that the defendant was not insane at the time she committed the crimes of murder, attempted murder, and tampering with physical evidence. As such, their verdict and sentence should not be set aside. And then we're going to talk about, this is Kevin Gregg's interview that we just watched. Defendant's claim of new evidence is deceptive and misleading. The defendant alleges that a reporter for Fox 40 WLBT informed defense counsel that Kevin Gregg, the defendant's father, told them that the defendant was placed in equestrian therapy as a young child due to experiencing auditory hallucinations. This statement is simply not true. The state hopes that this misrepresentation was unintentional rather than an intentional lie to this court. There's a word missing there. WLBT has released both an edited and unedited version of Kevin Gregg's interview, as well as a story in print where they stated that they had reviewed the transcript from the interview and spoke with both interviewers, and no such comment was made. See Exhibit A, article and interviews, and then it says, footnote 1, a physical copy of the videos will be provided to the court. We just watched the unedited portion. The defendant relies upon this allegation to claim that this new information supports Dr. Clark's diagnosis of unspecified schizophrenic disorder and is likely to lead to a different result at a new trial. The defendant ignores the fact that the jury did hear from Dr. Clark regarding his diagnosis of unspecified schizophrenic disorder. He testified that the defendant did not tell any medical provider prior to March 19th, 2024 about auditory hallucinations. The jury also heard from the defendant's therapist, Rebecca Kirk, who by the defendant's own admission, she trusted. The defendant didn't testify. The defendant saw Mrs. Kirk on the day prior to the crimes and failed to say anything about hearing voices or having any other symptoms. But yeah, but wasn't it in the records that she had heard them? Like earlier? I seem to remember that testimony. And I'm not sure if it was Mrs. Kirk. Is she the nurse practitioner? Or she was the therapist? Well, I'm sure we'll get there. Dr. Clark further testified that the defendant told providers at the jail after she was arrested that she had auditory hallucinations, and the voices took over her and told her to harm her mom. Specifically on March 28th, 2024, the defendant told her providers that she feels that something took over her and the voices were telling her to harm her mother. Didn't she also say that when she was on whatever the up to dosage of Zoloft was, that she felt like a zombie? And that's why they took her off of it? But I'm sure they're not going to point that out here. Despite this statement, the defendant told all other providers, including her own expert, that the voices she heard, which were only reported after the crimes, never gave her commands. The jury heard this testimony as well as the testimony of Dr. Amanda Giuliano and Dr. Jason Pickett. That was the state's expert that we spoke about at length. Dr. Giuliano testified that the defendant reported she started hearing these voices at the age of 4 or 5. Right. Which tracks with what her father said. Dr. Giuliano testified that it is not typical of schizophrenic patients to start hearing these voices at such a young age, but rather later in their teens. Dr. Pickett testified that he did not diagnose the defendant with schizophrenia. Dr. Pickett further testified that even if his diagnosis was wrong, that the defendant did not meet the McNaughton standard for insanity and that she was sane at the time of the crimes. Diagnosis of a mental disease or defect is only the first part of the McNaughton insanity standard. Regardless, there are 0 medical records, counseling records, and/or therapy records prior to March 19th of 2024 that mention anything about auditory hallucinations. Additionally, the defense knew prior to trial that the defendant received equestrian therapy, which was court ordered during her parents' divorce. In fact, this was referenced in Dr. Amanda Giuliano's report. Yes, and we heard also from Bridget Todd that they could not obtain those records because they were too long ago and they couldn't find the provider and the records didn't exist anymore. Dr. Andrew Clark, the defense expert, relied upon the precise clinical neuroscience specialist's records in rendering his testimony and report. He mentioned the defendant's prior court-ordered therapy. Yes, thank you very much, Unlock, because in my mind, this is very important as well. Her mom was with her, right, when she was seeing these providers, which a lot of teenagers would not be 100% truthful if their mom was in the room, right? And it stated previously, right, and her mom was with her and had stated previously, should count. Also, no one is addressing the fact that she was cutting. Yep. They admitted my daughter against my will because she told them she was cutting. I'm so sorry to hear that. But yeah, that's a huge part of this case too, that they keep just glossing over. Something was going on. Somebody said she did kind of look like a zombie the way she was walking in that video. Yeah, I agree. He mentioned the defendant's prior court-ordered therapy. CARLY was in therapy for a number of years when younger. In general, she did not find it helpful. She did not like or trust some of the therapists and found that some seemed to be trying to get information to use against her father. The therapy was court-ordered. Her mother encouraged it. Her mother was quite concerned that CARLY would turn into her father. Remember, she kept telling CARLY that. And they believed her father was a schizophrenic. He thinks he's bipolar 3. He was very, very convinced of that diagnosis and said that he had been diagnosed many, 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 many times. You heard it from his own mouth. The defendant introduced the defendant's medical records from Magnolia Counseling at trial. Included in those records was the intake sheet filled out by Ashley Smiley. When asked if the defendant had previously seen a counselor, she marked yes and stated that she saw a few court-ordered counselors due to issues with visitation. Father, Vicksburg, ages 5 to 10. This girl's been in therapy since she was 5. And her father even said she had suicidal ideations at the age of 4. Or at the age between the ages of 7 and 8. I can't his ramblings were so all over the place. I can't even remember. I know. That's just true too. And the fact that she had no emotion speaks to her mental health. America's version of what mental health disorders look like are so skewed. I know. Like she should have looked like something out of a horror movie. That's what that Dr. Pickett said. Well, she clearly knew the right from wrong because she was so calm in that video. To me, that is more indicative of a psychotic break. I'm a lawyer, not a psychiatrist, but the fact that she could remain so calm after she just shot her mother in the face means to me that there's definitely some kind of dissociative episode going on. If she was screaming and yelling and behaving like a normal person would, wouldn't that mean that she was not insane? I don't know. I'm beginning to think I am insane. Thank you, Yuri's math teacher, for gifting 5 memberships. You are so kind and generous, as always, to this channel. And to those of you who were just randomly gifted by Yuri's math teacher, thank her or him or her. I don't know. Is Yuri's math teacher a man or a woman? I don't even know. Thank you so much, Yuri's math teacher. I appreciate you so much. Yes, you're right, Dr. Berry. Not guilty by reason of insanity is a very, very high standard in the U.S. It's very, very rarely found by a jury, right? Very rarely. Lindsay Hendricks says his story about her being 8 years old and him reading the 10 Commandments and in the Bible to her, and she cried, really puts her journal entry mentioning evil or God isn't real into context. Yeah, right? Hmm. JB3 says she went from a healthy looking, beautiful girl to cutting her hair, wearing baggy clothes, and no longer smiling shortly after her mom remarried. The stepfather, not afraid to say it, but those are misread flags. She could have been going through something emotionally, right? I mean, the cutting to me is a big, big clue here. And you're right. Nobody is really addressing it or even talking about it. That's not just a phase that all teens go through. You know, there's some deeply rooted reason why that happens. Phoebe agrees with me. Screaming and freaking out is more indicative to me of someone who knew exactly what she did. Right. Hi, Darcy. Hopefully you'll get one. You just have to opt in to gifts and be participating in the chat, and you will see. Brandon says, plus, if you look at the appeal courts, how many new trials even get to a new trial? True. As Lizzie says, I don't see her getting a retrial. I think one retrial that we are covering that may be granted, and every day I check the docket and the decision is not out yet, is the Ashley Benefield case. Because in that case, they held the hearing and they called the jurors back in. And there was that one juror that it was alleged that she had lied on her questionnaire about being both a victim and a perpetrator of DV. And in my opinion, if the judge came to the conclusion that that juror did in fact lie on the questionnaire, I think that that is grounds for a new trial. Overturning a jury verdict is very, very, very difficult. It's a very, very difficult hurdle unless you can show something like jury tampering, juror misconduct, you know, and even in the Murdoch case, like the clerk interfering with the jury. But very rarely are jury verdicts overturned on appeal. But we'll see. Let's keep reading. Yeah, Mother Oates says the stepfather has no obligation to Carly, and the fact that he still supports her speaks volumes. I feel like the whole family knew that whatever happened that day was not Carly. I think that this medication issue needs to be looked into. There are a lot of experts that talk about this at length. That may have just caused her to snap. But in my opinion, to lock her up for the rest of her life without ever giving her the chance to get out, to get rehabilitated, to have the mental health treatment that she so, in my opinion, desperately needs, she won't get that in a prison situation. So scary. Where was I? Okay. More importantly, the defendant introduced the precise clinical neuroscience specialist records at trial as Exhibit D-19. Included at State's Bates number 000742. Bates. And we were talking about this the other night in the Karen Reed trial. It's Bates number, not Bate number. It states, she started going to counseling and seeking legal help in 2015 and continued for 2 years. Court-ordered equine therapy and therapy with an alternative counselor until she was stable and did not want to go any longer. So in 2015, she would have been 5 years old or 4 years old. That tracks. If she started hearing voices then. Based upon all the medical records and the interview from Kevin Gregg, there is a complete of support. I don't know. Complete what? Complete lack of support? Complete mountain of support? There is a complete of support that the defendant was placed in equestrian therapy for auditory hallucinations. Well, what? There's a word missing there. Rather, this therapy was court-ordered during her parents' divorce. This argument by the defendant is without merit, and the jury's verdict and sentence should be upheld. I don't know. I think there's a question of fact there. It was not error for the court to exclude and or limit witnesses by the defendant. And this is going to go to the fact that the maternal grandmother was not allowed to testify and the uncle. The defendant argues that it was error for this court to exclude 2 of her witnesses and limit the testimony of others. These witnesses were not named by the defense in her motion. These arguments are without support and merit. While this court did properly find that the defendant's discovery violations, again, that should say violations, but it doesn't, it says violates. The defendant's discovery violations were willful. The testimony the defendant sought to introduce actually came in through other witnesses. Yeah, but that's not the point. The court is aware that the state asked for discovery from the defense multiple times. There were multiple motions filed requesting the defendant to comply with discovery. Defendant failed to call any witnesses at trial that were excluded. Well, because the judge said no. The defendant failed to proffer any proposed testimony of any witnesses during the trial or during any pretrial hearing. Our appellate courts have repeatedly held that a failure to object contemporaneously at trial forfeits an issue on appeal. But they were told they couldn't call those witnesses. So what is there to object to? Okay. When testimony is not allowed at trial, a record of the proffered testimony must be made in order to preserve the point for appeal. Without a proffer, the court cannot know what testimony was excluded. He was very emphatic. We watched that pretrial hearing. He was very emphatic about, no, they're not going to testify. So that was the ruling. The defendant failed to name the excluded witnesses. However, the state is assuming the defendant is talking about Vicky Breland and James Daniel Floyd. During a hearing on August 19th, 2024, the court ordered both sides to make sure all discovery in their possession was exchanged by August 20th of 2024. On September 3rd of 2024, the defendant sent a witness list for the first time. It was not accompanied by any statements. Yeah, because they didn't take statements. You just have to summarize what they're going to say. This is okay. We'll see if he buys it. And then they say the following was stated during the pretrial conference. The court. The court went over S1. The court looked at it. For example, Vicky Breland is a witness closely identified with the defendant. That's her grandmother, Ashley's mom. The late disclosure, this court, that's what this court has a problem with a witness closely identified with the defendant. What is provided is not the substance of her testimony. Same with James Daniel Floyd. What the rules are concerned with is not a listing of witnesses. Nowhere in the rules does it say provide a list of witnesses. It says provide a name, the address, the substance of the testimony, written, recorded, or oral otherwise. When I look at Vicky Breland and James Floyd, Shira Higby, Trisha Gelbreth, those are witnesses closely identified with the defense. For those reasons, the court stands by its prior ruling. Heath Smiley. Mr. Smiley has made it very clear that he wishes to stand with the defendant. That's a witness closely identified with the defense. He will be limited to everything he's testified to before or the statements previously provided by the state. See hearing transcript from 9/10/24 at page 79. The defense failed to abide by any of the court's prior deadlines for discovery. The state asked the court to exclude testimony pursuant to Mississippi Rule of Criminal Procedure 17.9c. The court properly found that the defendant's failure to disclose these witnesses was willful and motivated by a desire to obtain a tactical advantage. The defense willfully refused to provide the state certain discovery in its possession. As such, it was proper to exclude these witnesses. Moving on, a lot of case law and citations. And this is all going to be argued at the hearing. So we don't have to read all 51 pages of it. But now we come down to this. In certain cases, a trial court has discretion to exclude a defense witness who is not disclosed to the state prior to trial. If the omission was willful and motivated by a desire to obtain a tactical advantage, that would minimize the effectiveness of cross-examination, and the ability to adduce rebuttal evidence is entirely appropriate to exclude the witness's testimony. The record must contain evidence that the defendant committed a discovery violation to obtain a tactical advantage before exclusion becomes the appropriate sanction. The record in this case shows that it was for a tactical advantage. Ms. Todd, Your Honor, I feel like talking about this now is somehow going to prejudice CARLY with the jury, so I'd rather, and that's the September 10th, 2024 hearing transcript, page 53. This failure to disclose was clearly willful and for a tactical advantage. The defendant's argument regarding the exclusion or limiting of witnesses fails, and it was not error for the court to limit and or exclude these witnesses. Should this court determine it was error, which the state denies, then any error was cured by the fact that BG, SR, those were both juveniles whose names were kept out of the proceedings until the prosecution started naming them and the judge started naming them, and Heath Smiley all testified at trial. Further, Dr. Andrew Clark testified and failed to consider any of Vicky Breland's interview as relevant in his opinion of whether or not the defendant was insane at the time of the crimes. Further, Dr. Clark testified about his interview with Heath Smiley. The defendant was able to present her theory of defense, and that was that she was allegedly insane at the time of the crimes. However, the jury did not believe that affirmative offense, I should say defense, but rather found that the defendant was sane at the time of the crimes. And then they go on to talk about the grandmother. Let's go to the chat for a second. Chet Christopher says she needs help, not jail. Avonlea Rising says, I hope she gets another trial. This is awful. Sophia says, cutting is a red flag, even cutting hair. Interesting. And I agree. I agree with you. Kathy's Law says her young life was full of counseling and that was not taken into account. A jury that doesn't comprehend life sentence is not qualified to make said judgment, right? Remember they came back and they had a question about what does that mean? Life without parole, they didn't understand. Okay. Going back to the testimony of the grandma. Included in the defendant's witness list was Vicki Breland, the mother of the victim, Ashley Smiley, and the maternal grandmother of the defendant. Ms. Breland had been in constant communication with the defendant and her defense team. Her proposed testimony was about Ashley Smiley's mental and physical health and CARLY's mental state from the fall of 2023 to the present. The state was not provided any statement from Ms. Breland. The defendant knew about this witness and failed to disclose her until September 3rd of 2024, after the court's deadline of August 20th of 2024. As such, this witness was so properly excluded. Bridget did point out to us that the court rules are different and that you have to exchange a certain number of days before the trial. And this was well within the number of days before the trial. And that it was actually the prosecution who did the late exchange, but this is their story and they're sticking to it. The following took place at the hearing prior to the court excluding this witness. Ms. Todd, the next witness is Vicki Breland, the maternal grandmother. And it's going to the statement she made, not to me, but the statements she made to the expert witness, Dr. Clark, regarding the family's mental health history. 9/10/24 hearing transcript at page 54. Per the defendant's argument at the pretrial hearing, the testimony she would have provided was what was provided to Dr. Clark. And that's completely different. For a jury to hear testimony from the actual witness, from the actual grandma, is going to have a completely different weight and effect on a jury than hearing a Dr. Clark say what the grandma told him. It just is. I think that if the jury was able to hear from the grandma and the grandma was able to say, like, listen, what happened, that's not CARLY. That is not who CARLY is. That is not what anything that she would ever do. CARLY has had mental health issues since her mother, my daughter, had to run away from an abusive husband when she was 4, and then her sister died, and then my daughter, Ashley, also had serious mental health issues from the time that she was a child, and now you've got the biological genes on both sides of both parents. But I don't know that the jury would have taken that into consideration anyway. But I'm just saying, with regard to this particular argument, I think it makes a big difference to hear from the grandmother herself than to hear Dr. Clark saying what the grandmother told him. What do you think? Yes, thank you, Mary P. I can't believe they didn't allow in testimony from the grandma to give the context. Laura says, I also feel that the jurors should have been privy to the wishes of the family. Yuri's math teacher says, in my opinion, a bad therapist is worse than no therapist. Yes. Yes. Parents should take responsibility too. I have problems with the gun. I have problems. I do. I mean, this girl is under psychiatric care and she's on medication and she's cutting and there's all these red flags and there's just a loaded gun laying around the house. I'm not victim blaming, but I have a problem with that. I have a big problem with that. What do I think the appropriate verdict or sentence should be? I think she needs serious mental health help. And I think she should be incarcerated in the type of institution that can provide her with intensive therapy, but give her the opportunity to get out after, let's say, I don't know, they offered her a 40-year plea deal, which was turned down. Let's say they work on her for 25 years or so. I don't know. But give her the opportunity to be rehabilitated and placed on, I don't know, the proper medication. I'm not saying we should just set her free. Child needs special help, says Sophia. What do you think, Melissa? I know I can't get past the gun either. Right. But for the gun, we would not be here. She would not be there. Debbie agrees about the gun too. I know. Sad situation all around. Why did they have this trial so fast? Thank you, Sandala Ray, for asking. Well, when I had her attorney on my channel 2 different times, everyone had that question. And we also watched some of the pretrial. Judge Dewey K. Arthur in Rankin County was the judge. He was a very no-nonsense, pushing this train down the track kind of judge. And I got the impression from Judge Dewey K. Arthur, that he wanted this thing to go to trial quickly because, in my opinion, I felt that he really cared about CARLY and he wanted her out of the situation that she was in. Because she was being held in the Rankin County Jail, there was no youth ward. So to keep her safe and keep her out of the gen pop, they kept her in solitary for 23 hours a day from the time that she was arrested all the way back in March. So for 6 months before this trial happened, she was in solitary for 23 hours a day. And you can only imagine the mental health effects that can have on a person, an adult. Imagine a 15-year-old. And Bridget Todd told us that she felt so horrible about this that she went to visit her every single day so that she could get her out of her cell where she was alone for so long. And I thought really that the judge had like a heart and he really wanted to get her out of that situation. And now, even with this conviction, without the life, she's with the sentence of life without parole as it stands right now, she is in a youth facility where she will be until she's 18. And then she will go to the adult prison, but she's not going to get the mental health help that she needs by going to a mental health facility. So that's the thing. Well, Melissa, that's what they do, right? They, if not rehabilitated, then they keep you until they say that you are. And that's what happens in prison mental wards and mental hospitals. But I don't know what the answer is. Really? I don't know what the answer is. But I don't think that we should be locking our kids up and throwing away the key. That's just, I don't know. Carla says, I think the stepfather should also be responsible for the loaded gun not being locked in a gun safe. That's interesting too, because Bridget told us too, in Mississippi does not have those laws. I said, because my question was, what if CARLY took that same gun and went to a school and shot up the school? Would the parents be held responsible? And Bridget said, no, not in Mississippi. So we see that happening in other states. We saw that in Michigan with Crumbly. We're going to see that in the Georgia case. Mississippi, they don't have it. Melly says, I personally don't believe the grandmother's testimony would have changed the verdict. I believe she put more weight on the other witnesses, especially those in the field. But I think that is why this thing was pushed so quickly. They also did not waive speedy trial because they wanted to get her out of there. Dr. Berry said, I think that Ashley kept it there due to not feeling safe with CARLY's father. Well, Kevin, we've seen him. But, I mean, had he ever tried to break into the house before? Was he a threat? I still don't think that leaving it in a place where a child could get access to it, especially a child that has issues, that's seeing therapists, you're putting her on medication, she's cutting. Just can't. Yeah, those guns should have been triple locked. Knowing her mom and stepdad knew she had problems, said all around, she definitely needs help. I agree. Right. And Deanna says, I don't think the expert who just got his degree, Dr. Pickett, and has never worked with children should not have been allowed to diagnose CARLY. Yeah. And he also tried to diagnose Kevin without ever having interviewed him or met with him, which is against the Goldwater standard. So maybe we're going to get into that a little bit as well. Back to the document. The defendant was able to call their expert, Dr. Andrew Clark. Dr. Clark said he had an interview with Vicki Breland, but he did not rely on anything she said when rendering his opinion. If Dr. Clark determined this testimony was not relevant to the defendant's sanity at the time of the crime, it certainly would not have been relevant or likely admissible at trial. I disagree. I fundamentally disagree with that. Would have given the jury more of a look into who CARLY is and who she was and how that was not like her. It's not the grandmother's job to testify about her mental diagnosis, but to give the jury a little more of a glimpse into who her mother was and who she knew CARLY to be. Again, the defense took the trial strategy of saying this wasn't a whodunit, but rather a question of whether or not the defendant was sane at the time of the crimes. As such, it was proper to exclude her testimony. James Daniel Floyd. James Daniel Floyd was also disclosed on September 3rd. However, he had been in constant contact with the defendant and the defense team. He is the husband to the defendant's maternal aunt. His proposed testimony was regarding his personal knowledge and observations regarding the events on March 19th, 2024, and the investigation by the Rankin County Sheriff's Office. No statements were provided. Moreover, the testimony is improper and irrelevant as he is not an expert in investigations, and the defense to this case was insanity, not that she did not commit the crimes. The following took place at the hearing regarding James Floyd. The judge. All right, who's the next witness? Ms. Todd. The next witness is James Daniel Floyd. Judge. All right, show me what you turned over in relation to Mr. James Daniel Floyd. Ms. Todd. Your Honor, the only thing we're anticipating calling Mr. Floyd about is just what he saw on the day of the investigations. I've not had personal conversations with Mr. Floyd. He's just going to confirm the demeanor of Mr. Smiley during the investigations when the police were at the house. The judge. How is that relevant? Ms. Todd, I think it will be relevant to the case in chief when we start talking about the investigation that's gone on, the cross-examination with the judge. Well, I thought you weren't. He's not testifying to the investigation. What is he going to testify to about the investigation? Ms. Todd, Your Honor, I feel like talking about this now is somehow going to prejudice CARLY with the jury, so I'd rather the court. Ms. Todd, you can't hide evidence. You can't go to trial and them not know what this witness is going to say. That is basic 101 law. Mr. Camp, can you cite me a single case, a single one where a defendant got to go to trial and not tell them what the other side was going to say? Mr. Camp, I definitely agree. We have to turn over our evidence to you. And that is included in the 9/10/24 hearing transcript. And she says, the defense attorney agreed that they are required to turn over evidence. As such, the exclusion of this improper witness was correct. I think it was summarized. I don't think you have to he never gave any statements. They had access. The state has a lot more resources than they had access to all of these witnesses as well. In fact, they had been speaking to these witnesses as well. So I don't know. I mean, I don't think the judge is going to agree with this argument because it was his ruling to begin with. Will it have legs on appeal? I don't know. BG and SR. The defendant also listed BG and SR in their September 3rd, 2024 witness list. The state previously disclosed these witnesses to the defense and provided investigators' notes and recorded statements for these individuals. The defendant did not provide any additional proposed testimony or statements. As such, the court limited their testimony to what was provided in discovery. This was proper. The following took place at the hearing. The court. Who is the next witness on your list up above? Ms. Todd, the next witness on our list is SR followed by BG. These are the same witnesses the state's going to call, and we're calling them for the same reasons, Your Honor. The court. Okay, so you didn't turn anything else over? No statements from the juvenile witnesses, correct? Ms. Todd, I haven't even spoken to SR, so no. The court. What about BG? Ms. Todd, BG spoke to him briefly, but the testimony is the same thing that the state recorded in their interviews. The court. All right, then they won't be allowed to testify to anything other than what's in the state's interviews. As the court appointed you to case law, there's no exception to the discovery requirement for the defendant just because they're listed in the discovery by the state. So you can't elicit anything that's not in their report. Ms. Todd wasn't planning to. That is the hearing transcript. Heath, now turning to Heath Smiley. Give me 2 seconds. I got to turn this fan down. It's freezing in here. Hold on one second. The defendant also listed the living victim, Heath Smiley. His proposed testimony would include, among other things, Ashley Smiley's mental and physical state. The state requested any medical records the defendant had regarding Ashley Smiley and were told they had none. Additionally, Heath was allegedly going to offer testimony about CARLY's behavior and mental health issues from the fall of 2023 through the present. The state was provided no statements to this effect. In fact, during his interview with law enforcement, Heath said that he did not know why CARLY would do this. The only thing he knew of was that she was on medication and seeing a therapist for anxiety and depression. The state provided the defense with several recorded statements and/or videos of this witness prior to the August 20th, 24 discovery deadline. The defendant, through counsel, stated on August 20th, 2024, that she sent Heath and other witnesses typed up questions and they sent responses. The state agreed that the attorney's questions would be considered attorney work product. However, that the responses were not and should not be provided to the state pursuant to discovery rules. The defendant never provided the state with any statements from the victim or any other witnesses. Additionally, Heath Smiley would not provide a statement to Dr. Amanda Giuliano, the state psychologist, but he did provide an interview to the defendant's expert, Dr. Clark. Dr. Clark relied on this interview in preparing his report and trial testimony. As such, despite not providing Heath's statement to the state, it was allowed in through Dr. Clark. While the defendant was being evaluated by Dr. Jason Pickett, the state psychiatrist, the defense attorney mentioned that she would have Heath Smiley reach out to Dr. Pickett to talk about the defendant zoning out. He did call Dr. Pickett. Nothing in the conversation with Heath Smiley caused Dr. Pickett to opine anything other than the defendant was sane at the time of the crimes. The following took place at the pretrial hearing regarding Heath Smiley. Mr. Camp, we don't have any written statements from Heath Smiley, Your Honor. The court, did he give you any oral statements? Mr. Camp, just what the same thing he's given to both sides. I mean, that's the court. Great. So all he'll be able to testify to is what was provided in the state's discovery, correct? Mr. Camp, that's correct, Your Honor. The court, okay. So he'll not be testifying to anything other than what he's testified to in open court or what he's given a statement of. Mr. Camp, that's correct. And that is the pretrial hearing, page 42. Mr. Camp, Your Honor, Dr. Clark talked to Heath Smiley, and that is in Dr. Clark's report, so that has been furnished. Ms. Todd, would you like me to proceed to Mr. Smiley until we can? The court, sure. Ms. Todd, same thing with Heath Smiley. He's given a statement, which was listed in Dr. Clark's report as a 90-minute Zoom conference call. He's done a witness interview, which we received from the state, and several just the body cam footage of things that happened on March 19th. That's what we're calling him to talk about. The defense expert, Dr. Andrew Clark, relied upon his interview with Heath Smiley. Heath provided information to him about Ashley's mental state and physical health, as well as him telling Dr. Clark that the defendant would zone out when Ashley Smiley would be fussing at her. Heath further told him, and he relied upon the fact that the defendant seemed to, quote, develop problems with her memory. As pointed out above, the defense agreed that Heath Smiley would testify consistent to what he provided to law enforcement at a prior hearing. The defense also wanted to rely upon the information Heath Smiley provided to Dr. Andrew Clark. Despite that interview was not being recorded or produced to the state, Dr. Clark was able to testify at trial consistent with the information he learned from Heath Smiley. As such, there was no limit to his testimony. Again, I think it has a different impact when you hear it from the witness directly, as opposed to hearing it from another witness. And in this case, the hired expert. Right. Judy makes a great point. Judy makes a great point here. And she says, I wonder if the judge would have allowed Ashley's mother to testify if she was going to say, CARLY was a raving lunatic. We fear for our lives every time we saw her. Mm-hmm. Lindsay says, in the same breath that it seems CARLY would zone out whenever Ashley was yelling at her dad in that interview, supposedly, CARLY even told him that he didn't have a backbone towards Ashley. Heath, you mean, yeah. Charlene says CARLY will spend the rest of her life disassociating. In Mississippi, that's considered humane and just. Kathy's Law says Texas pays for appeals for indigent people on taxpayers' dime. I wish Mississippi did that too, since I'm sure she would qualify since she has no income. She didn't qualify for a public defender because it was based on her extended family's assets, which is ridiculous when you're 15. Tracy Talks a lot, says Pickett said so many unprofessional, unethical things about other professionals and diagnosed without seeing the patient, speaking more about CARLY's dad than he even did about CARLY. Mary's math teacher says it's a travesty. Kate Mick, based on what we now know about jurors' dangerous lack of understanding fundamental law, perhaps we should be overturning jury decisions on the regular. Well, yeah, let's get to that jury instruction that the judge refused to give on reasonable doubt, because that's interesting. We're only on page 32. All right, where is it? Remember, the defense wanted the jury to be given a definition on reasonable doubt, and the court said no. Oh, here's the part about Rebecca Kirk testifying about crime and punishment. Remember, she testified that crime and punishment, CARLY wanted to read crime and punishment, and they were trying to use that as some evidence that she was, dangerous or premeditating. And here the state argues Rebecca Kirk's testimony was proper. The defendant argued that the testimony regarding the defendant reading crime and punishment was not disclosed and that the testimony of this witness was improper. However, the defendant was in possession of the Magnolia counseling records prior to the state receiving them. It is absurd to say that they were not provided this information. Ms. Kirk's testimony was solely based upon her treatment and the treatment records of the defendant. The defendant received these records and evidence from the state on August 6, 2024. Pursuant to the Mississippi Rule of Evidence 503F, the state could not speak to this individual other than for trial scheduling purposes about her treatment of the defendant. However, nothing other than trial strategy stopped the defendant from speaking to this provider. Well, Bridget Todd told us the provider would not speak to her because she lawyered up and said, we're not talking to you. I think they were afraid of being sued. Rebecca Kirk and the other witness who prescribed the medication. All argument regarding Rebecca Kirk's testimony is meritless and improper. The defendant introduced the medical records of Magnolia Counseling during the trial. These are a complete and accurate copy of the records for therapy sessions and initial intake for the defendant with Rebecca Kirk. These records contained the statement about the defendant reading crime and punishment. And see how she has it underlined? And remember, the prosecutor said to this witness, Rebecca Kirk, isn't it true that you underlined crime and punishment in your notes because you thought that that was a really important detail? And she said, no, I used to be an English teacher. That's just the way that when you write down the title of a book, you underline it. That's just what you do. And then she kind of just glossed over that and was like, oh, okay, well. The defendant argued in her motion that Ms. Kirk's testimony was one of the last statements the jury heard prior to beginning their deliberations, and it was. Because remember that the state did not call these witnesses until their rebuttal case. That's when they called the providers of CARLY, because so many people were asking during the defense's case, why didn't the defense call in the providers, the ones who prescribed CARLY the medication and her own therapists? And Bridget Todd told us because they wouldn't speak to us. We didn't know what they were going to say. And we had Dr. Clark. And then in their rebuttal case, that's when the state called these witnesses to the stand. Ms. Kirk's testimony was authentic and truthful. Her testimony was based upon her treatment and records of the defendant. The defense cross-examined Mrs. Kirk about her testimony, specifically crime and punishment. However, her statements were not even close to being the last statement the jury heard prior to deliberations. In fact, the jury also heard the direct examination of Dr. Amanda Giuliano, then the defendant's cross and redirect. Additionally, they heard from Dr. Jason Pickett, and then all 4 attorneys involved in case argued during closing arguments to the jury prior to their deliberations. Rebecca Kirk's testimony was likely prejudicial to the defendant as she saw her the day prior to the crimes and did not notice any sort of mental defect or disassociation as alleged by the defendant. However, all evidence is prejudicial to one side or it would not be relevant. This testimony was more probative than prejudicial and therefore it was proper. See Mississippi Rules of Evidence. The defendant knew the state intended to call Rebecca Kirk. The failure to object to testimony at trial waives any assignment of error on appeal. And that is citing a 2009 case, citing a 1985 case. Mrs. Kirk's testimony was proper and admissible, and the contents of that testimony were previously disclosed. As such, the argument regarding her testimony is meritless. Oh, thanks, Black Rose. If you're enjoying this video and chat, please give Melanie a thumbs up and subscribe. Share. You'll need to hit the bell under all notifications, the bell, to be notified, and it's free. And thank you, Black Rose. I have the best moderators on YouTube, and I also have the best chat on YouTube. You guys are amazing. You guys are very incredibly generous and kind to each other. And we have so many survivors of so many things in the chat, and you just the way you support each other in the comments and in the chat just makes me very proud to be your cupcake. Thank you, Diane, for gifting 5 memberships. Oh, and Yuri's math teacher gifted another 5. And look at all of these new 10 members. Shelty Mom, Hey Sue, Ann Hank, Sherry Rollinson, Paulette Kelly. Welcome, welcome, welcome to all of you. Stephanie, Debbie, Pepper's mom, Rose Colored Sky, and see you. I don't know what that says, but welcome to all of you. I think you're going to like it here. Scott. Here's my email, fanbase@mlittlelaw.com. She can't babysit your kids, can't lend you money, and she won't fly your kids to an island. You forgot that I can't be anybody's pen pal. I read all emails. I just do not have a chance to respond to all of them. I have very limited time, but I spend it here with you in person. So isn't that even better? Okay. Dr. Pickett possessed. He's possessed. Dr. Pickett possessed the proper expertise necessary to testify in this matter. The defendant alleges that Dr. Pickett did not possess the proper expertise necessary to testify in this matter due to his inexperience with evaluating children and adolescents. Oh, I hate typos and I hate misspellings. I should say adolescent, TS. With forensic evaluations in general and his inadequate background in child and adolescent psychiatry. During the voir dire portion of Dr. Pickett's testimony, the defense attorney stood up and stated that they did not object to his qualifications or Dr. Pickett being tendered as an expert in emergency medicine and forensic psychiatry. To say that in another way, the defendant did not object to his qualifications or opinions at trial. Dr. Pickett is triple board certified in emergency medicine, psychiatry, and forensic psychiatry. He testified that he regularly evaluates defendants through the Mississippi State Hospital. The defense attempted to discredit Dr. Pickett and his qualifications during cross. However, they confessed his qualifications during his direct examination. The failure to object to testimony at trial waives any assignment of error on appeal. I don't know if that is accurate statement of the law in Mississippi. I've not read these cases, but there are exceptions to that everywhere in most states, so I'm not sure. This is a 2009 case, quoting a 1985 case, quoting a 2018 case. During Dr. Pickett's testimony, he referenced his experience in treating children within the emergency room setting, as well as in general psychiatry. I don't think he did. He references, I don't know that he treated any children, but maybe 1 or 2, but not a lot. More specifically, he outlined that he had conducted over 100 forensic evaluations prior to this case. Interestingly, the defendant's expert, Dr. Clark, corrected the defense attorney when they sought to introduce him as a forensic psychiatrist. He said, rather, he should be admitted as a child and adolescent psychiatrist. Yeah, Dr. Clark was very, very honest and forthcoming and very experienced, in my opinion. Both Dr. Amanda Giuliano and Dr. Jason Pickett testified about the difference in a general psychiatrist and the forensic psychiatrist. Forensic psychiatrists focus on how mental health conditions and disorders apply to the criminal justice system. Dr. Pickett is more than qualified to offer the opinions and testimony he provided in this case. His testimony was properly admitted without objection by the defendant. I don't know if it's use it or lose it kind of thing in Mississippi. Can't really give you my wholehearted opinion on that. But if I have any Mississippi attorneys in the chat, let me know. Is it a use it or lose it kind of thing? And that's all they had to say about Dr. Pickett, which I found interesting. I thought their arguments were so much longer on other points, but not so much on Dr. Pickett. And Dr. Pickett, did they even address Goldwater? Because Dr. Pickett did try and undiagnose Kevin Gregg, and that was a huge part of his testimony. Do you remember? I mean, like, he had an 86 page report. That's right. Law junkie Dr. Clark didn't call CARLY the devil, so I think that qualifies him over Pickett. Your mom. I know this is nothing funny about this, you guys. Nothing funny about this, but sometimes we have to make jokes or we're just going to cry all the time. Dr. Pickett learned everything he needed to know about kids by watching an after-school special. Also, the fact that he worked in state hospitals meant that he worked with the worst of the worst. So to him, if you weren't acting like you were in a horror movie, you couldn't possibly be disassociating, not to mention that he admitted that he had never treated any patients ever who were in a disassociative state, right? Sometimes I conflate my cases, so please, if I'm wrong, I cover a lot of cases at the same time. Tell me if I'm wrong. Didn't he say that he had never, ever treated a patient with dissociative episodes or disorders? Conjunction junction, what's your function? How about I'm just a bill sitting on Capitol Hill? Remember that one? Schoolhouse Rock. Scott. Our Gen X references get the best of us sometimes. It was proper to deny a jury instruction defining reasonable doubt. Okay, this is interesting because this is an interesting question of law. We have 11 minutes until that interview is going to come up with Catherine Newman, who wasn't, to the level of the Ashley Benefield evil stepsisters, in my opinion. But I'd like to see her do an interview because I'd like to see what she's really like outside the courtroom. And I love women attorneys. Power. Women power is great. But I want to say, yep, he did say that. He also said he didn't work with children, says Margaret. Monique, yes, he did say that. Yes, the judge, the report did not come into evidence. Lindsay Hendricks, that is correct. It didn't come in, but he spoke about a lot of stuff that I thought was inappropriate about Kevin Gregg. And he went on to say, well, he couldn't have been a schizophrenic because, the last thing I would do is prescribe Adderall to a schizophrenic. Like, it was ridiculous how much time he spent on Kevin Gregg. And also, you're not allowed to diagnose somebody under the Goldwater rule that you've never examined or met with. So, a lot of that I think was kind of prejudicial, more prejudicial than probative. No, Pickett was not from Boston. Clark was from Boston. I think he said that he was taught at Harvard. I think it's a magic number. 3 is the magic number, Paul. 3 is the magic number. Iceman remembers Schoolhouse Rock. We're all in the same class, my friends. Hi, Kiki Kazuma, but behind you made me laugh. We are teleporting to a time back. I know. It's so funny when people are behind and they're chatting with us, and it's so funny because they think they're in real time and they're, talking about things we talked about like an hour ago, which is fine. I love that. I love that you guys are so collaborative and so participatory. But it's even funnier when people are commenting in real time after the show is over in the comments. It's hilarious. Hello, Anthony P. Hello, good afternoon to you, sir. Please hit like to push the video out. When they, like, we did a giveaway the other day, and that reminds me, Blessed Mom in Texas, I owe you your mug, and I have to do that after this. We did a giveaway, and it was, you had to put hashtag cupcake in the chat to be entered in the giveaway that StreamYard does, and then they do like this whole like drawing at the end, and then somebody wins a prize. And people like on the replay were putting like hashtag cupcake in the chat, which was so cute because they forgot that they weren't watching us live. Thank you, Joseph Kane, for your super sticker. I appreciate you so much, as always. Gifting, donating, so very nice. Hi, Jason. This judge was slick in that he appeared to care for CARLY while suppressing a bunch of relevant testimony, and that is tricky. You know what I watched last night? An old favorite, Good Will Hunting. Anybody like Good Will Hunting? That was that's a classic. That is a classic, especially, well, I can't tell you the line now because I was going to play Guess That Movie, but I'll have to do that. So I'll have to save it for later. All right. But now those of you who have listened today know where it comes from. No shenanigans, no ballyhoo. No shenanigans, no ballyhoo, no something else. I can't remember. All right. The defendant alleges that the court erred with it. Failed to provide, and maybe when it failed to provide the jury a definition of reasonable doubt. Our courts have long held that reasonable doubt defines itself, and the court should deny jury instructions attempting to define reasonable doubt. Mississippi state courts do not allow judges to give a jury instruction on reasonable doubt. That's a 2005 case. It's already 20 years old. The court acknowledged that federal courts allow similar instructions, but our courts do not. Yeah, also, you don't allow bootleggers to serve on a jury, so, there's that. The Mississippi State Supreme Court has repeatedly and consistently asserted that reasonable doubt defines itself. And they cite cases from 2003, 1994, 1991, 1990, 1988, 1982, 1981, 1976, and 1932. Right? Oh, you do? You watch everything I recommend. What are you watching now, Monique? My husband always says, where did you find this one? Did you watch Jury Duty on Amazon Prime? That's awesome. Yes. In this episode alone, we traveled from 20 to 2026 and to 1920. Yes, we did. Oh, yes. Oh, yes. Oh, yes. Oh, yes. We both reached for the gun. Oh, yes. We both reached for the gun. That's in my feed on YouTube, and I watch every single one that comes up because I love the people that dance to that song. Here's what they say. Periodically, our courts have explained why jury instructions defining reasonable doubt should be refused. The jury instruction as given, in effect, tells jurors that they should be able to state a reason why they have a doubt. Such an instruction is erroneous because in our jurisprudence, jurors are never required to articulate any explanation of their decision. Tell me if this makes sense to you, my friends. The Mississippi Court of Appeals stated that it was proper to refuse the jury instruction defining reasonable doubt because the instruction was superfluous. The jury received a plethora of instructions concerning reasonable doubt. The jury had been fully informed that before it could return a verdict of guilty, it had to believe beyond a reasonable doubt that the defendant was guilty. Similarly, in this case, all the state's jury instructions instructed the jury to find the defendant guilty only if the state established those elements of guilt beyond a reasonable doubt. As such, denying a jury instruction attempting to define reasonable doubt was proper, and this argument is without merit. I don't know where to go with that. We've watched a lot of trials lately, and this jury did not understand what life without parole meant. They wanted a definition of that. So don't you think reasonable doubt is not within the province of the jury, that there are a lot of people who are not lawyers who don't understand exactly what reasonable doubt means? That it means that if you have if you're back there thinking of any other way that this could have happened or any other explanation of why this could have happened, that is reasonable doubt. I think it needs to be defined. So I disagree with that also, but nobody's asking me. Let's see. They say it's going to start. They say it's going to start in 3 minutes and 44 seconds. It's only 7 people waiting and they have no chat. So we're going to rebroadcast it so you guys can watch it with me. Oh, you started The Lost Flowers of Alice Hart yesterday. What do you think? Grateful Glow 1111. Tell me. What do you think so far? Right, Lindsay. Absolutely cannot be on a jury if you have any ties to a roadway contract. Oh my gosh, around the world. Hi, honey. How are you? Long time. Went into labor with my first baby while watching Good Will Hunting in a theater in Westwood in LA. Favorite movie. I love that. Love it. Too much white lightning causes blindness or hooch or, grappa. Yep. Thanks, Phoebe. Karen Reed's jury for sure didn't understand reasonable doubt. That's ridiculous to assume they know what that means. Yep. Trish says, yeah, but people don't use their brains. Hence, what does life without parole mean? Yep. Law junkie. But these jurors have to be 21 years old due to the inability to understand long-term consequences, but before age 21. Brain development, but a 14-year-old should. Yep. Are we there yet? That's a great name. If the judge cannot define reasonable doubt, how can any juror ever find reasonable doubt? Right. Right. That's what I'm saying. Rara says Karen retrial was full of reasonable doubt, but was still hung. Don't understand. Still don't understand. Thank you, Edward Scott. Ask 10 people what reasonable doubt is, and they won't be able to give you a definition. Yep. I'm with you on that. Right. Right, Phoebe, which is exactly what Karen Reed's jury did. They searched around for another way to explain the crime. That is reasonable doubt. It is. Cat artist. She loves Good Will Hunting too. For Carly, guilty was narrowly defined as an adult, says Little Cupcake. No more shenanigans, no more tomfoolery, no more ballyhoo. That was the line I was thinking of. No more shenanigans, no more tomfoolery, no more ballyhoo. Oh, thanks. Yes. Andrew Burkhart is in Delphi, and the judge had a very twisted take and instruction on reasonable doubt. Has she already talked about reasonable doubt? Was that from Andrew Burkhart's live last night? If you guys want a boots on the ground view of what's happening inside the Delphi courtroom for the trial of Richard Allen, Andrea Burkhart is a law tuber. She's there in person. There are no cameras in the courtroom. There's no audio being released. And she does live. She did a live last night. I did watch part of it, and she's giving her thoughts on what's happening in the courtroom. And she's she's wicked smart. She's wicked smart. I mean, she's so much smarter than I am. She's got like a legal brain where she speaks in legalese. Everything is very meticulous. And so if you want some great coverage of what's going on in the courtroom at Delphi, check her out. Her name is Andrea Burkhart. Adam Lally resignation, we can only hope, says, after watching so many trials recently, I think the definition of reasonable doubt should always be given. Led by the monkey and the engineer fabricating their own theory. That's a Jerry Garcia song. The Monkey and the Engineer. Is that a reference for you, Joseph Kane? Did you know that? Connie Coelho says, it's so scary to think about putting your life on some jurors' hands. Yep. Exactly, Trisha. Why does reasonable doubt have to be unanimous? Surely, if even one person voted reasonable doubt, it means there's doubt. Yep. I was thinking the roadway contract could have been an overseer with a chain guy and that chain gang. That's interesting. Hi, Radine. How are you, my dear? Thank you so much for coming in with a super sticker. Thank you. Thank you. David Reese says bootlegging is still a thing in Mississippi due to dry counties. Really? They have dry counties in Mississippi? They used to have them in Utah. I didn't know about Mississippi. I did not know that. Thank you for enlightening me, and Joseph Kane for your super sticker. It doesn't sound like their audio is very great. We're not going to be able to get closed captions because it's live. So I'll put it on when it comes on. It's WLBT Plus. Stand by. We're standing by. Tennessee has dry count. Oh, wait. This music. Tennessee, Helene says Tennessee has dry counties. Fun fact, county where Jack Daniels is made is dry. Okay, that's just bizarre. Stephanie Blanchard lives in one of 2 dry counties in Arkansas. Does that mean that you can't consume alcohol there? Like you can't even go buy it in another county and then bring it home to drink it? Or you have to go to another county to buy it? That's crazy. We have like liquor delivery here. Judy, the best thing about Delphi is the judge didn't let them say the defendant is presumed innocent. When the defense said it, the prosecution objected and the judge agreed. What? So you're not afforded the presumption of innocence in Indiana? What's up with that, Judge Gull? I don't know.
On our goals. Every day, our dedicated teams are hard at work, ensuring.
All right, we're waiting for the interview. This is not it. This is some sort of commercial. Ray Dean says, in my mind, reasonable doubt would be, but how, but why? We know when, we know where, and we know what.
For WLBT Plus. My name is Kara Shirley, and I'm your digital news desk host. I am joined today by the Rankin County ADA, Miss Catherine Newman. You probably recognize that face, seeing her there. She was the prosecutor in the CARLY Gregg. And so, Catherine, thank you so much for being in here with me today. I know that
The mic's not
let me
on.
make sure I've got all of my audio working. There we go. All right. So let's talk. And I asked you this question right before we came on air, and I want to ask you it again real quick. How did you get the CARLY Gregg trial?
So our office actually, excuse me, each attorney kind of handles a specific set of. I handle crimes against children, all the sex cases for a certain part of the alphabet, and then I took over the murders in January. And so, of course, her case came in after.
Yeah, I started here with WLBT. I started here in March. Actually, I started March the 6th was my first day. So like this was very, very new, very fresh, me seeing that and being here in this area. And I almost, when I watched it at first and heard what happened, reporting the story and everything, I was like, what have I moved into?
Yeah.
Yeah, not long at all. And it was really kind of scary.
Your audio stinks.
Just to hear, it's just to think that a child could do that to their mother. That I think is the part that was the most terrifying, is that a child could do that to their mother, a seemingly brilliant child. I mean, she was a brilliant child. She is a brilliant child. High scores on the ACT at the age of 13. I don't know that I ever took the ACT.
Well, I did, and I did not ever make a 30 on it. Yeah.
So
yeah.
it is crazy. So let's see. I've got going in and out. Talking about your audio. So what I'm going to do, because this is live and in real time, I'm going to get Keith in here to see if he can fix your audio, make sure that it's working okay. If you guys still have issues with her audio, please let me know. And I'm watching your comments. So we are live now on Facebook. We're live on our website. And if you are tuning in on any of these channels, TikTok, we're live on our TikTok channel as well. Thank you all so much for tuning in. So CARLY Gregg, in case you are tuning in, you don't know, CARLY Gregg is the then 14-year-old, now 15-year-old, who was tried for murder, for killing her mother, and for attempting to kill her stepfather, and then tampering with evidence. And Catherine here is the ADA that prosecuted her. and was very successful in the eyes of the law. I guess it was a successful case, but when you think about it, you take a step back and you look at what happened. There's no winners in this case. There's just no winners.
That's right, Kara. That's exactly right. And maybe if I talk a little closer to this, that'll help. We have talked about this. Both Michael Smith and I have said that pretty much anytime somebody talks to us about this case is because every case I have is a violent crime. So that means there is a victim of a violent crime. And so for me, no one wins in that instance because you can't make them whole again. This family lost Ashley Smiley, and now they've lost CARLY Gregg because of her actions. So, I mean, they actually lost 2 family members. And so it's even sadder than normal because if you have, a defendant who's not related to the victim, you have 2 separate families that have been affected by a tragedy. And in this case, it was just a very large family that was affected by her actions.
Right. It's so sad. And then, I mean, you even think, I'm sure maybe a lot of people don't want to think about this, but then you got Kevin Gregg, who is CARLY's biological father. And I mean, even though they did not have, according to what was reported in the trial and things, didn't have the best relationship, he's completely lost his daughter.
Yeah. So I think before she committed these crimes, I think it had been about a year or a year and a half since she had spoken to him. But that doesn't mean he stopped loving her, right? I think even in his interview with you guys, he's like, I still love her. I hope she, gets right, but I still love her. And
This is the state. Oh, sorry if I blew your ears out. This is the station that interviewed him and then released the unedited video. And this is streaming live.
so you're exactly right. I mean, there's her dad, there's Ashley's parents who are her grandparents, there's Heath's family. He and Ashley were married almost 4 years when that happens, but still his mother was pretty close with them. I mean, there's definitely a whole community. And then that doesn't even take into effect the children that went to Northwest Rankin. So
Right.
Ashley Smiley was a teacher and from all accounts was a beloved teacher. And so they kind of closed her classroom down for the rest of the year and made like a makeshift memorial for her. I mean, so you have all these other innocent children who were affected by a terrible tragedy.
And then on top of those and all that we've already spoken about, you talk about the friends of CARLY, who, especially the friend that came over, that she got to come over. I think as a parent, while I do feel for the child that came over, the friend, I also feel for that child's parent, having the thought that you were the one that dropped your child off into that traumatic situation and not knowing. I mean, obviously the parent didn't know, but there's so many people that are touched by this.
That's
many
right.
people.
That's right. And their lives will forever be changed because of decisions that were made.
Mhm.
And, we unfortunately talked to that child and her parent and explained to them, like, you had no way of knowing. If you had known
Right.
this, you wouldn't have taken your child there.
Right.
And unfortunately, if it wasn't that friend, it probably would have been some other friend too.
Right. And so let me ask you the question real quick, because I know a lot of people have asked this and brought this up. Why was that friend not charged with anything? Because she was there. CARLY told her what was going to happen. She showed her mother. When CARLY told her friend to go outside because the stepdad was coming home, she could have ran and got help then. So what is the I guess the situation looking into that?
So first of all, the state of Mississippi, it's the Milano instruction, and there's case law that says there's no duty to intervene in a crime. So that's whether
No duty to intervene in a crime. It's also like a good Samaritan law, right? But trust me, if she could have prosecuted another child for this, she absolutely would have. Yeah, they're streaming, but they're not looking at anybody watch. It's so weird that they're looking at each other. I know that's what you don't do when you're a streamer. You look into camera. And that's why their audio sucks too. But maybe they fixed it.
it's an adult or a juvenile, right? So
Wow.
no one has a duty to intervene. So from a legal standpoint, she was never going to be charged. But from a common sense standpoint too, I mean, we have another juvenile who's
Mhm.
gone over unknowingly to a house she thought she was going to help her friend at, and then she, greets her at the door, "Are you squeamish around dead bodies?" And then tells her what we've all heard, like, "I put 3 in my mom. I got 3 more waiting for my stepdad." do you want to wait outside while I take care of him?
Wow.
But she had a loaded gun. I mean, and while she has this loaded gun, at some point, I think the friend, and I can't remember if she testified to this or not, but may have put it down, but shows her other guns that are in the house. And so, you know, I'm 40 years old, and there are a lot of things I would do if somebody had a loaded gun,
Yes.
and they told me to go do something.
Right. If I walked into the house and the 14-year-old, I'm listening.
Yes.
I'm listening, especially when they've already proven to me that they're not above committing a crime.
Killing their own mother.
Right. Exactly. So that's a good to know as to why the child or the friend, the child, she is a child,
Yeah.
was not charged with this because she didn't do anything wrong.
That's right.
So
The only thing she was guilty of was being a good friend.
yeah. Bless her heart. She may question that going forward. I think of the trauma on these kids, and it breaks my heart. It absolutely breaks my heart.
So sorry to interrupt you.
No,
I
go
do
ahead.
want to say this too. That's one of the things that when we talk to the parents of children like that on any of our cases that involve violent crimes, we recommend they get counseling or therapy in some way. You know, we say, hey, we'll help you get her in touch with somebody, get him in touch with somebody, you know, whatever the circumstance is. And some places will provide.
That's so kind of you, but you're not going to provide any counseling for Carly, the defendant, the one who's clearly mentally ill and had a psychotic break. But, you know, the friend that came over, we're going to provide her with counseling, or him. They have one person in their chat. One person in their chat, and there are 89 people watching on their live stream. We have more. We have 1,200 watching here, just for numbers' sake.
Provide family counseling as well. And so, I
Mhm.
mean, you know, just because the trial is over doesn't mean the trauma is over for all the people that were involved in it.
So you said in some cases the state will provide counseling in situations?
Yeah. So if you're the victim of a violent crime, we can through the Mississippi Attorney General's office. They have the Victims Compensation Fund, and so they provide funding for these people to actually go and get therapy, counseling, whatever it is they need. Sometimes those that are a little bit farther removed might not qualify for those services, but we certainly have people that we can recommend for them.
Right. So then her stepdad, Heath Smiley, he would then qualify for that because he was a victim.
Yes, absolutely. And when I spoke to him on the phone, I explained to him that process and asked him to fill out the application and told him, you know, whether he thought he needed it or not. It was always good to file the application. And so, yes, he has the ability to get those services.
Well, that's good to know. That is good to know. Let's talk then, since I brought up Heath, let's quickly touch on this because I've heard you talk about this in other interviews, but I want to touch on this because I know a lot of people have asked, was there something inappropriate going on between CARLY, Gregg, and Heath Smiley?
We have no information to report there was anything improper other than Heath being a loving stepdad. So law enforcement had Heath's phone, law enforcement had Ashley's phone, CARLY's phone, her burner phone, and her regular phone. CARLY went to, you know, as we heard in trial, CARLY had been in therapy or counseling even since before she knew Heath Smiley, never reported any sexual abuse, never reported it to any friends, and then was interviewed by a psychologist and 2 psychiatrists and never mentioned anything about sexual abuse. So no, there is nothing to indicate that there was anything improper going on with them.
So that, because I've heard a lot of people ask the question, well, there could have been a phone that was hidden that they didn't know about or things like that. So even the hidden phone from CARLY they had.
Yes, that's right. That's right. So her actual phone that mom and stepdad knew about, they had taken that phone at some point, and so she was communicating with her friends on the burner phone. And the messages that you may have seen that were
It's not a burner phone. Can somebody explain in the chat what it is? It was like an old iPod that she found. It's not a burner phone. She did not go to the store and buy a burner phone like drug dealers do. It was not a burner phone.
introduced at trial, those all actually came from her burner phone. So yeah, that was the secret phone. So again, assuming if something had happened, she would have certainly had more information on that phone than the one they had access to.
And what did they search the house? I mean, I know that wasn't their first thing in their mind that what they're looking for, but was the house searched and there was nothing found in the house that would indicate something like that happening?
That's right. So I don't know how much of this we're supposed to talk about, but since we're live, there was one sexual device found in CARLY's room under her mattress. Law enforcement, because they want to rule.
Wow. She brought that up in her closing. Now she's calling it a sexual device. And I asked Bridget about it, and she said, yeah, it was never brought up during the trial. She talked about it in her closing, but what happened was one of her friends, like they were learning about sex ed in school or something, and one of her friends gave her a gag gift. And that's what this was. And now she's going to try and make it out to be something that it's not. Oh, I can't wait to hear this.
Wow, any possibility.
Listen.
One sexual device found in Carly's room under her mattress. Law enforcement, because they want to rule out any possibility, right? We're not assuming that he did anything, but they're like, hey, we want to do our job. That was sent to the Mississippi Crime Lab. The only DNA that was found on that belonged to Carly Gregg.
Okay. Well, that's good to know because I know that I'm sure you have
Oh, well,
seen that. or
let's
heard-
put that out there. Let's put that out there, what Carly Gregg did in her spare time. Are you gross? Is anybody grossed out by this? What's in your nightstand? Yet it was under her mattress. Yep, sexual. Anybody grossed out by this? It was something that a friend gave her as a joke.
heard that have been asked that a
Yes.
lot.
Yes,
Is that
yes,
happening?
yes.
And
Wait.
sure.
That was found on that belonged to Carly Gregg.
Okay. Well, that's good to know because I know that I'm sure you have seen that or heard that have been asked that
Yes.
a lot.
Yes,
Is that
yes,
happening?
Yes.
And I know a lot of people want to look at a stepfather stepdaughter relationship and maybe side eye it a little bit. But my husband is my oldest daughter's stepfather, but that's her daddy, that's his daughter. You know what I'm saying? So it's like I understand the love that a step parent can have for their child. While it may not make a lot of sense to people, especially with him being shot by Carly and Carly killing his wife, I can see the support.
That's right. And it's the only daughter he's ever known. And every human being processes trauma differently. And so while his reaction might not be mine or yours,
Right.
it's his.
Yes.
And there's no playbook on how you're supposed to respond in this type of situation.
There really isn't. There really isn't. And if there was one, you would know because you deal with this.
Yes. And I can assure you, everyone responds differently.
Yes, they do. Well, I'm going to ask you another question about.
Tell us about how people behave during a dissociative break or a dissociative episode. Does everyone behave differently too, or should they behave like they're in a horror film, like your expert, Dr. Jason Pickett said?
Or a question rather about Ashley Smiley and something. I know you said earlier you don't have a TikTok, so you probably have not seen this, or maybe you have, but people have been saying that you can hear in the video, the security camera footage after the shots are fired. And Carly is in the kitchen and she's texting that they say that you can hear Ashley say, "Help me." My question to you is was that a possibility with
No.
her injuries?
No. So when I've unfortunately watched that video numerous times.
Well, that's interesting. Everyone did think that she was saying "help me" in the video, and she's saying no. That's not what happened. Wow, imagine. Hold on, let's hear that again. Luckily, we can rewind this.
To you was that a possibility with
No.
her injury? Carly is in the kitchen. Have been saying that you can hear in the video, the security camera footage.
Yeah, it was all over. It was all over Twitter. It was all in my comments that people were saying, after you could hear the shots ring out, that you could hear people were saying you could hear Ashley saying "help me," and then Carly went back in the room, and then came back again. And this attorney saying, no, that's not what happened. It couldn't have been possible.
After the shots are fired and Carly is in the kitchen and she's texting that they say that you can hear Ashley say, "Help me." My question to you is was that a possibility with
No.
her injuries?
No. So I've unfortunately watched that video numerous times. When you watch it and turn the sound up, you hear Carly shoot, you hear Ashley Smiley scream, you hear Carly shoot again, you hear a thud, which we believe based off the trajectory of the shootings and the casings, that's when Ashley fell and hit the ground. And then about 4 seconds pass and you hear another gunshot. There was testimony at trial by investigator Burnell that there was stippling in this gunshot. And so that means that the gun was in 3 feet of her when she was shot, 30 inches actually. So a little less than 3 feet. There is no way one of those projectiles was lodged in her brain and one was lodged in her neck. So when I watched back through that video, Carly's texting, and we know now she's on Ashley's phone, texting with Heath, "When will you be home, honey?" And then Heath responds, "It'll be a little while." And I believe what she says is, "Oh, that's great." And then hits the thumbs up button. And so then she starts humming. And so I think it's actually Carly that people are hearing, and not Ashley.
Because I mean, I listened to it and I was like, well, if someone is implanting that thought into my brain that she is saying that, it could sound like that. But I was like, you're the perfect person to ask because you would know for sure.
Yes.
So let's talk about now with Carly being a minor here in the state of Mississippi. A lot of people don't understand why was Carly given such a quote unquote harsh sentence.
So in the state of Mississippi, any person over the age of 13 that commits certain crimes, murder being one of those, the use of a firearm also is one of those crimes. There's certain qualifying offenses where you are automatically considered an adult. You don't.
So lock up your damn guns. Why don't you have a law that says that parents need to lock up their guns from children? If when those children find those guns and kill someone, you're not going to be able to prosecute the parent, but you're going to charge a kid as an adult. It's so backwards.
Have to go to youth court to be adjudicated up. And so murder, particularly murder with a firearm, is an automatically certifying event, meaning that in the eyes of the law, because she was over the age of 13, she is considered an adult. And so in July of this year, the Mississippi legislature changed the sentencing scheme for a juvenile convicted of murder. It used to be life and only life. And now the sentencing range is between 20 and 40 years. And again, that as of now, that's a day-for-day crime, but between 20 and 40 years or life if affixed by a jury. And so the sentence that Carly Gregg received was within the sentencing guidelines for murder. For attempted murder, it is life if affixed by a jury as well. And so that's why she got the 2 life sentences. And of course, Judge Arthur ran them in legal words concurrently, but in layman's terms at the same time.
She was the first juvenile to be tried under this statute. This is the case of first impression. She's the first child to be sentenced under this new law that took effect in July.
So tell me, what does that mean then for Carly? Because she got life without parole. Does that mean she is literally never going to see the outside of prison, or how does that work?
Yeah. So as the law stands right now, yes. And so we talked about this just a little bit before we got on the air. Technically, the murder statute does not differentiate between life with and life without parole, because the parole statute specifically prohibits murder from being a parole eligible crime. So it says you can't get parole if you're convicted of murder. However, after Miller v. Alabama, the U.S. Supreme Court came in and said juveniles could not automatically be sentenced to life without the possibility of parole. And so during our sentencing, we had the jury consider for both the attempted murder and the murder, the Miller factors. And they ultimately found what we'd asked them to do, and that's to hold Carly in prison without the possibility of parole. We think she's a danger to society. And so, again, that's within the sentencing guidelines. If she had been charged with capital murder, they would have been able to consider that. And so when we were looking at it, we were like, well, it's better to err on the side of caution and give them the option of the possibility of parole than to have it come back on appeal and them say, well, you guys should have given the jury these 3 options.
Right. So you're just basically just covering your bases, making sure that you're making it appeal proof, I guess.
Yeah, trying to. Yes, trying to. Yes.
So let's talk about the biological father, because we heard his name a lot during the trial. We've heard his name a lot in the appeal.
You've interviewed him.
But let me ask you, why was Kevin Gregg not subpoenaed or not asked to testify, whether it be for the state or the defense? You probably can't answer it on the basis of the defense, but why was he not subpoenaed?
So the state never had an interview with Kevin Gregg, right? He never came to law enforcement. Excuse me. He never responded to, I personally did not reach out to him. But both the psychologist, Dr. Manny Gugliano, and Dr. Jason Pickett, the psychiatrist, attempted to reach Kevin Gregg multiple times in order to try to get a statement from him about any mental health history that he knew. I mean, that's the primary reason for talking to him. From our standpoint, Carly had not talked to him for a year and a half. So as
Yeah.
far as proving her guilt, there really wasn't any reason for us to subpoena Gregg to the trial to
Mhm.
talk about something he didn't.
Oh, were you able to find him? Because it's funny how he goes straight to this reporter who's interviewing you right now and gives this whole, we listened to it, it was a half an hour long, the outtakes. Said that he was talking to Carly from jail, remember? So he did speak to her. He, according to him, he spoke to her while she was in jail before the trial. And he's absolutely able to be found when WLBT wants to do an interview with Kevin Gregg. I want to take this back a second because Bridget Todd said he
Guilt
wouldn't communicate with them
stemming
either.
from Gregg,
But
right?
he
never
said
came
to
law.
this reporter that he wanted to help her. I wish somebody would have called me. Isn't that what he said?
But let me ask you, why was Kevin Gregg not subpoenaed or not asked to testify, whether it be for the state or the defense? You probably can't answer it on the basis of the defense, but why was he not subpoenaed?
So the state never had an interview with Kevin Gregg, right? He never
Mhm.
came to law enforcement. Excuse me. He never responded to. I personally did not reach out to him,
Mhm.
but both the psychologist, Dr. Amanda Gugliano, and Dr. Jason Pickett, the psychiatrist, attempted to reach Kevin Gregg multiple times in order to try to get a statement from him about any mental health history that he knew. I mean, that's the primary reason for talking to him. From our standpoint, Carly had not talked to him for a year and a half. So as
Yeah.
far as proving her guilt, there really wasn't any reason for us to subpoena Gregg to the trial to
Mhm.
talk about something he didn't know about. And so that's why we personally didn't reach out to him. I did have conversations with the defense attorneys, and they said that they had, I think that he had harassed them, and so they had blocked him or something to that effect. So I
Mhm.
can't say why they chose not to call him, but maybe it was
Wait a second. They harassed him and he blocked them? Well, this interviewer did not get that in her scoop. Hang on.
attorneys, and they said that to subpoena Gregg to the trial to
Mhm.
talk about something he didn't know about, and so that's why we personally didn't reach out to him. I did have conversations with the defense attorneys, and they said that they had, I think that he had harassed them, and so they had blocked him or
He
something to
harassed
that
them.
effect. So I
Mhm.
can't say why they chose not to call him, but maybe it was based off the conversations that they had that I was not privy to.
Right. Well, I mean, we've heard them talk about that. There was no,
She just said the defense attorneys said that Kevin Gregg harassed them, as in the defense attorneys, and blocked them.
or that they couldn't get in touch with him or something. But then we've heard saying that they did talk to him before. So I'm not sure. I guess I would need to speak with Bridget Todd. to
That's right. Yeah,
find
yeah.
out
I
about
can't.
that.
Yeah, I can't answer for them. I can say that I personally did not reach out to him, but both our doctors did in an
Mhm.
attempt to try to see if he could provide any helpful information. One about his medical history, and
Right.
two about hers. And so that was another thing that I had specifically asked from the defense. Hey, do you have any medical records for him? Give me anything you got on him. Our
Mhm.
doctors want them. We want to make sure that we have a full picture. And the only thing that we were provided, which is what was introduced at trial, was like 3 pages. A psychiatrist, I think, that he saw in the course of the divorce between he and Ashley Smiley.
Okay. Well, that's good. So y'all you didn't see the need for him, not in a rude way.
Yeah, that's
but
right. That's
yeah.
right. He just could not provide any relevant testimony. I mean, my
Mhm.
job was to prove, right, once we got the case, to prove that on or about March the 19th in Rankin County, 2024, Carly Gregg did kill her mom, did attempt to kill her stepdad, and did tamper with physical evidence. And throughout the course of the investigation, it was learned that Carly had not spoken to him for a year to a year and a half. And so
Mhm.
we knew he didn't have anything to do with it, and we knew he
Yeah.
didn't know anything about that.
Right. I know when we spoke with him, he said that he did talk with Carly. When she was in jail, she called him, that they had texted for a while, and that according to Kevin Gregg, that Bridget Todd had put a stop to that. My question in this, and is his stating that, and maybe you can shed some light on it, is if Kevin Gregg and Ashley Smiley did have joint custody of Carly, should he have not, once Ashley is no longer living, the custody would have fallen to him. So why, I guess I'm wondering, why was he not involved in the the picking of her attorneys or anything like that. Can you speak to that? And you may not be able to.
So I can say I know by looking at their custody agreement that they did have joint legal custody. So meaning that he still had legal rights over Carly. His rights had not been terminated, but
That's right.
Ashley had
He had
physical.
rights over her like she was a piece of property. Just like Bridget Todd said, that's like the system there. It's like children are treated like property. And let's put this in perspective. And thank you, Anne, for bringing this up. Susan Smith, who killed her 2 young boys, received 30 years to life, and she gets to petition for parole. Yet let's lock up Carly for the rest of her life and be giddy about it. Like Sarah and Schwackenhauer said, all that's missing from this interview is a bottle of wine and a charcuterie board.
Custody. And so you're right. After Ashley was killed, there was no longer anyone to exercise physical custody other than him. However, it's sort of weird. In private practice, I did some chancery work. So in a typical situation, take aside the fact that somebody's committed a crime, then yes, usually what would happen is that FIO dad would petition the court then and say, like, I need physical custody as well as legal custody. In the eyes of the law, on the criminal side, Carly Gregg was an adult. And so no one but her has the ability to say who her legal counsel would or would not be. And in the eyes of the law, she alone has to make the decision on whether she pleads guilty or not guilty and goes to trial. And so to talk kind of a little bit about that too, Kara, I know there's been talks about the fact that Carly Gregg wouldn't have qualified for a public defender. And I've spoken about this before. She had a public defender. There was a public defender assigned to her before Miss Todd and Kevin Camp entered an appearance. And so just to put any end to that, she absolutely had a public defender. And then at indictment, she would have been assigned a different public defender if she requested one. I mean, certainly a 14-year-old and 15 at the time who had no assets qualified for a public defender. And the ones that we have in Rankin County are excellent.
Yeah, that's
Well, that's interesting. We didn't know that. That'd be interesting to hear. Be interested to hear what Bridget has to say in response to that. But Bridget and Kevin Camp did represent her pro bono. So she's saying she should have kept the public defender, who certainly wouldn't go to visit her every single day the way that Bridget did. But
it's good to know because it was brought up, it was mentioned, and the question has been asked, if she has no assets, and how is she affording the attorneys? Now, of course, in other interviews, Bridget Todd has stated that they did it pro bono, which is great. That's awesome for them to do that, step up to do that.
I think the only interview that she gave was on my channel. 2 of them, I think. I guess they're watching. Hey, WLBT.
That, but they also said that she couldn't get a public defender, but she could have. She did have one.
That's right. She had one. They entered an appearance, and so a new public defender was not assigned to her at indictment. So what happens is if it comes from the sheriff's department, it's a little weird in our county. So if it comes from the sheriff's department, it originally goes to county court, and so that's where she had a public defender assigned to her. And then once a case is indicted and it goes over to circuit court, then there's a separate public defender that would have been assigned her case. But at no point would she been left without representation.
Okay. Well, let's talk about the guns now. So with all the school shootings that have happened and all the kids having these guns and getting into these violent situations, violent crimes, we hear a lot about parents being held accountable for it, whether it be because they knew the child had issues or they had left the guns out in the open for them. Now, obviously, with Ashley being deceased now, can't hold her accountable for it. But Heath Smiley was a parent too in the same household. If they knew that she was having some type of emotional,
Great question.
Mental health issue by taking her to the psychiatrist and medications and therapists and things like that, could they not be, or could Heath not be held responsible for having loaded weapons in the home of a child that he knew was having issues?
So I think, again, to be clear, the only issues that were reported were anxiety and depression. And obviously, when you have somebody with anxiety and depression, one of the things that you worry about for me would be suicide. And so I, as a parent, I would want to keep our weapons locked up. I'm not aware of any law in the state of Mississippi that requires that, right? So there's
Mhm.
certain things like child neglect or child endangerment. You would have to show some injury to the child. And of
Right.
course, in this case, the child is the one who was causing the injuries. You know,
Mhm.
she wasn't the one that was injured. And
Right.
so, again, I think good practice for any parent would be
So if she committed suicide, in that case, you would have prosecuted her parents? What kind of word salad nonsense is this? This is a good time for the word salad emoji that we have for members. Words. This is like, I gotta take that back a second.
I'm not aware of any law in the state of Mississippi that requires that, right? So there's
Mhm.
certain things like child neglect or child endangerment. You would have to show some injury to the child. And of
Right.
course, in this case, the child is the one who was causing the injuries. You know,
Mhm.
she wasn't the one that was injured. And
Right.
so, again, I think good practice for any parent would be, you know, to try to keep your firearms out of reach of children, particularly, you know, if there is someone that has mental health history, whether it's anxiety or depression or anything else like that, you know. But I'm not aware of any law that requires that they do so.
Okay. I'm gonna jump in. I want to talk about the appeal now, but first I want to look at our social media stream and see if we got any questions here
It's not an
from
appeal, it's a motion for a new
people.
trial. At least get your legalese right.
I'm looking. I have to. It's a lot. There's a lot.
Yeah, yeah.
There's not a lot. You have
Okay,
80,
Miss
70
Oceans
people
Small
watching.
says, I'm late. Has the stepdad's questionable involvement been addressed? And it has been addressed. And if you want to touch on that just real quick, so she'll.
Yeah, sure, Ms. Hutchins. So, as we spoke about earlier, law enforcement looked into any issues that may be at play, right?
Adam Lally's resignation just went into the other chat and said, y'all smiling too much. It's weird.
So they had Carly's phone, Carly's burner phone, Ashley's phone, and Heath Smiley's phone, and you know, also the benefit of interviews with all of her friends and medical providers, and there was never any abuse suspected or alleged.
All right. Awesome. So it has been investigated, and there's
Awesome.
nothing.
That's
There's
right.
nothing that is apparent now. So let's talk about the appeal first. So the one that was filed by by the defense, it was 9 pages.
Hey, and I want to stop you. I'm sorry, this
Okay.
is just technical. So the appeal is following the circuit court level. So
Okay.
the appeal would be like if this motion is denied, then that goes
Gotcha.
up to the Court of Appeals in the Mississippi Supreme Court. So it's just
No, I
words.
appreciate it.
Yes,
Yeah,
it's
no, I
just legal
appreciate it.
words. We call things
It's
crazy stuff in our world. But so what they filed was a motion for either a new trial
Mhm.
or JNOV, judgment notwithstanding the verdict, which just means they're asking the judge to set aside the jury's verdict. And so that's handled there in the circuit court.
Mhm.
And then the circuit court judge, Judge Dewey Arthur, can either grant that or deny that. And then if he denies that, then the appeal would take
Then the
place.
appeal.
So
Okay.
sorry, I just wanted to clarify.
No,
that.
I appreciate that. Please don't let me sit here and sound
Yes.
stupid. if
No,
I'm
no,
saying
you don't
something
sound
wrong.
stupid. You don't sound stupid. You know.
But no, I thank you for that. But so
Toy Thomas is over there in the chat too, and she's usually over here. So Toy, if you're going back and forth, say hello.
the defense is the JNOV.
Mhm.
It was filed and it was 9 pages. Yours was a little longer. It was 48 pages. I have it here, have it all printed off here. So let's talk about this. Let's talk about them alleging that she did not get a jury of her peers. Just talk about that.
Yeah. So I mean, I guess you make whatever arguments you can find.
Yeah.
And so in the state of Mississippi, you have to be over the age of 21 and able to serve on a jury.
Mhm.
And that's pretty clear. There's cases out there that say the legislator can set up guidelines to determine who is a qualified juror, who is a qualified elector. You know, you can vote at 18, but you can't serve on a jury until 21.
Can't be a
There is
bootlegger
nothing
or
in the
gambler.
law in Mississippi and or the United States and or the constitutions that require that you be tried by a jury of peers at a similar age. It basically says it has to be a proper elector, so somebody that is registered to vote, that lives in that county, and the
Mhm.
jury panel as a whole should be made up of the citizens that live in that county that are qualified electors. So there was never a chance that 14 and 15-year-olds were going to be selected for this jury.
Right. And yeah, it makes me I could think too, when I hear that people are concerned about CARLY Gregg not being emotionally mature enough to be held as an adult. But then we want to use the argument that we should also have a
Yeah, we should bring
jury.
12 of them in.
Yes.
12 teenagers.
Exactly.
Yeah.
So
Yeah.
I can't imagine that being fair to the children either coming in.
Right. Right.
Having to submit them to that trauma. But so peers, I mean, since she's being tried as an adult, those were adults.
That's right. Those are a jury of her peers. They were Rankin County citizens who are qualified electors. And so one of the things I pointed out in our response is at no point did the defense object to the jury panel as a whole. And so there's plenty of cases out there that say, for instance, there are some rural counties where, it comes up where there's a racial question on the panel doesn't have enough of a certain color. And so they can go to the judge and say, Judge, we object to this panel. We don't think it's a fair makeup of our county. And then the court has to say, okay, well, this is how they were selected and has to show that it was at random. So it doesn't necessarily have to be a statistical number of people that are made up of a certain class. But again, age is not a protected class for juries. Religion, sex, color, race.
But you cannot be a habitual drunkard in Mississippi or a common gambler. They're not allowed on the jury. So are you allowed to question someone about their drinking habits and their gambling habits? Really strange.
Those are protected classes. Age is not one.
Age is not one. Well, let's talk about now they're talking about the equestrian therapy that they claimed that Kevin Gregg spoke about in an interview with us, which he did not. But you're saying, I believe I've heard you say that they had information on that equestrian therapy before the trial ever happened. Is that correct?
Yeah, absolutely. And I even talked about that in our sentencing phase. So when CARLY went to see, I'm trying to remember now, I believe it was Precise Neuroscience, when she saw Olivia Lieber there, the nurse practitioner, Ashley and CARLY reported to her that she had had this equestrian therapy, which for people that are not involved in horses, it's horse therapy, right? They use these horses kind of like as a therapeutic animal. That therapy was related to her parents' divorce. It was court ordered. And then at some point, Ashley even puts in her paperwork, and then Olivia Lieber pointed out that that counseling ceased. Basically, when CARLY no longer needed counseling, they stopped doing that. And so absolutely, the defendant knew about that. They knew that she had participated in that. It was referenced there. It was also referenced in Dr. Gugliano's report that they were provided a copy of. And then I believe that their expert also referenced, he didn't specifically talk about the equestrian therapy, but that CARLY had received therapy and counseling subject to court order during her parents' divorce.
So they knew it.
That's right.
They knew it.
That's
So,
right.
Well, yeah, they knew it. But allegedly, Kevin said that she went to equine therapy because she was hearing voices at a very young age.
and maybe they're alleging that he said that it was because she was hearing auditory hallucinations. But I mean, we know that that's not the case. But
we don't know.
That's
That's
right. I
not
watched
the
both
case.
interviews. He did not say anything like that. And again, we had medical records, counseling and therapy records that went back to the time of Ashley and Kevin Gregg at the times, Ashley Gregg and Kevin Gregg's divorce from back when CARLY was, I don't remember now, 4 or 5, something like that. She never mentioned auditory hallucinations. Those were not mentioned until 9 days after she had been arrested for murdering her mom and attempting to kill her stepdad.
Wow. So never, not once.
Not a single record of anything about hearing voices, about having lapses in time, about having problems with any kind of voices, any personalities, nothing of that nature. The only thing that was in her medical history prior to that time was anxiety and depression.
So let me ask you a question, a hypothetical question as an attorney. So if they put into their JNOV that this is their wording, that he said it in an unaired portion of our interview, and that did not happen. So because that is in writing to the judge, is that considered perjury? Is that considered a lie to the court?
Can
Having
we
that,
sue
that
them?
particular
Can we
word?
sue her? Can we get her in trouble? I don't know if she specifically said that it was your unaired interview. I don't know if she named you specifically or WLBT in her moving papers, but I'm going to go check now since you're trying to get her in trouble. So
Wording, because you just talked to me about wording.
Yes.
So
Yeah.
how is that, could that play out?
So let me say this. So say that was my filing and I had put something in the filing that I later learned was not accurate. As a duty, as an attorney, we have certain rules that we're required to follow, the rules of professional conduct and the rules of ethics. You are to be truthful with the court at all times. So even if it was not an intentional misrepresentation, if I later learned something that I had put in a pleading was inaccurate, in fact, it happened in this case. In my response to their motion to try to exclude a drug screen, I included the wrong federal grant. I said that our youth court was under this grant. And then later, after I'd filed that, I realized that's not the right grant. So we contacted somebody in my office, not me, contacted the board of supervisors. We got the right grant and I filed an amended pleading, right? Because that's what you're supposed to do. So if I had filed something that I later learned, whether it was intentional or not, I would file an amended pleading stating new information has come to light that this does not appear accurate. And just for the record, if I had said something about you guys, I would have been beating down the door out there saying, hey, please take this down until we can figure out what's going on. And so, lying to the court intentionally is a sanctionable action. But again, it does have to be intentional. And so I would hope, based off the situation, the hypothetical situation that you're talking about, that whoever did that would have some justification for why they said what they said and be able to, thankfully, they don't have to answer to me.
Right.
They would have to answer to the court on why they had put something like that in a pleading.
And in your rebuttal, you even said, we hope that this
TV.
was just an error. Like
Yes.
you even extended some grace in your rebuttal. We hope that it was just an error. So you've referenced so many court cases in here, so many. There was none referenced in the defense's JNOV submission, but you've referenced a lot. And I want to talk about
she did mention WBLT Fox 40 in her moving papers.
the insanity. We know CARLY had some mental issues, but she was not legally insane. So, explain. I know we heard a lot about the McNaughton, but tell us a little bit more about the McNaughton theory.
Yeah, so I want to talk two things, competency and sanity. So competency, which the defendant said they had never called into question, they actually had. There were, when she had a public defender, they filed a motion to have her assessed for drug and alcohol and also competency. And so there were other times where they had called into question. So competency is whether or not a defendant can communicate with their attorney, whether they have the ability to understand the proceedings and the nature of the crime that they've been charged with. Basically, can they help their attorneys at trial? And so the defense has said, well, competency was never an issue. However, it was raised. And so we had Dr. Amanda Gugliano evaluate CARLY, and she determined that, in fact, she was competent, right? She knew what was going on and she could assist and could remember facts, which was important to us because if you can remember facts, that means you knew what happened.
Right.
So insanity is a defense. So if you're not competent, we could not have proceeded to trial until either competency is restored or somebody then goes out to the state hospital and they stay forever if they're never competent. But she was competent. So insanity, and that's why you didn't hear about it in our case in chief, is because every defendant is presumed sane. So the law says if you committed a crime, you're presumed sane. And basically the defendant doesn't have a burden, but it sort of shifts to them to say, okay, well, this is why this person didn't know right from wrong. So McNaughton is the standard. You have to have a mental defect. And Dr. Pickett talked about this. And he said, look, at the end of his testimony, he's like, look, even if my diagnoses are wrong, right? Even if you believe Dr. Clark and you don't believe anything I'm saying, that gets you to the first step. And that's, does the person have a mental disease or mental defect? So again, anxiety or depression can qualify for that. And certainly Dr. Pickett also found some other diagnoses that he thinks meet CARLY, as well as Dr. Clark did. So, right, she gets to the first step, the first hurdle. So then the second step is, did you know right from wrong? Did you know your actions? And we believe that, There was no question about that. I mean, when you watch that terrible video, you see that she knew that was her mom's phone. She knew her mom's passcode. She knew right where the loaded weapon was. She knew what part of the house her mom was in. She had spatial awareness. Dr. Pickett talked about her sitting on the stool and putting the gun behind.
Again, she knew where the loaded weapon was. Why was there a loaded weapon there? We're just going to gloss right over this because in Mississippi, it's perfectly fine. But if she killed herself, then they would prosecute the parents, but not if she killed other people.
Her, making sure
backwards.
that the dogs didn't knock it over.
Right.
That showed that she knew the gun was dangerous. When her friend comes over, well, first of all, before her friend comes over, she kills mom at 4:14. At 4:16, she starts calling, FaceTiming, and texting with multiple friends.
4:14 to 4:16, 2 minutes. Wow.
Yes,
Okay.
yes.
I didn't
So
realize
she
that.
immediately kills mom, walks right out into the kitchen, and when she's texting Heath, that's at 4:14. And so then she, takes that phone and the gun and goes out of the camera view, comes back in to let the dogs out, and that's when the camera is ripped out. At 4:16, she starts texting with her friends. Her friend that got over to her house got there at 4:58. Text and said, "I'm here." So there's this large portion of time where CARLY is texting with friends, calling again, and FaceTiming. I mean, this isn't somebody that is just like out of her mind. She's
Yeah.
responding to these people. She's calling them by the right name. She knows their boyfriends and girlfriends' names. She
That's
knows their
not
nicknames.
what a
She's telling them,
disassociative. That's not what a disassociative episode is. Because she could text and she knew people's names. Means she was.
up. Don't call 911. You can't do that. One of her friends said, don't hurt yourself or someone else. This is on a call. And she immediately says it's too late. Again, she knew what she was doing. And then, the main thing is insane people don't run because they don't know that what they've done is wrong.
Right.
And so we know
that?
that she fled the scene once she realized that she, I guess, was unsuccessful in whether or not she killed Heath.
Yeah. I like when you just pause and think about it, it's overwhelming. It is overwhelming to think. I have 2 teenagers. I have a 16-year-old and I have a 13-year-old. And I immediately went home every night I try and hug them. Hug them. I love you.
Yes.
Did you go home and lock up your guns?
Yes. I mean, and to think when you carry that child and you love them so much that literally the person that brought CARLY into the world, she chose to take her out.
Yeah.
And
seemingly, of course, it's not the state's responsibility to prove the why, but seemingly over vapes.
Something so silly.
So silly. It was, someone said this during the trial on our live stream. They said,
Vapes? I don't even know if it was ever established that it was vapes. Was it? I thought they were saying it was marijuana, not vapes like tobacco, like vapes like THC or like, who knows what was in that thing? They were bootleg. That she bought them from a friend at school.
said she made she gave a permanent fix to a temporary problem.
I think that's a great explanation of what she did.
I mean, because it's really a permanent,
It is.
assuming that this JNOV doesn't go through. And so let's talk about it again. What do you think, Judge Arthur, after he takes his pregnant pause
and eats his pork chop, right?
Yes, and eats his pork chop, eats his good pork chop every day in the live stream, people were saying, what's for lunch today, Judge? But, let's take the pregnant pause, and, that moment was great. But what do you think, how do you feel the outcome is going to be based off of what the defense has submitted, what you have submitted? Do you think that he is going to set aside anything?
I mean, when you look at their motion, and kind of one of the first things that I pointed out in my response here is that their motion actually fails to abide by the rules. You're supposed to point to specific facts and then support it with case law. So they haven't done that. But even taking that aside, the things that they have argued do not entitle them to relief, right? I don't think that Judge Arthur should set aside the jury's verdict. So some of the cases that I pointed out in there talk about on appeal, there's different standards of review that the Court of Appeals and the Supreme Court have for different types of cases and different alleged errors by the court. And one of the things that I pointed out was in an insanity case, which is pretty rare, right? It's rare that a defense takes a case to trial and actually claims the insanity defense. We just don't see that a ton. The Court of Appeals and the Supreme Court have said we give the highest deference to the jury on insanity cases because that's who determines whether or not somebody was sane at the time is the jury.
Mhm.
And so they're saying the jury, we believe the jury got it right. And they'd have to show some grave reason on why the jury didn't have all the information to have it set aside. And we don't believe that it should be set aside at the circuit court level or at the appellate level. I mean, we tried to do kind of what we talked about earlier, even in our jury instructions where we gave the jury the possibility of parole. I mean, we tried to do everything we could to make sure that no case is perfect, right?
Yeah.
But that this case did not come back on appeal because we do abide by people's civil and constitutional rights.
Mhm.
And we want to make sure that it was a fair trial. We believe the jury got it right and that the sentence and the verdict should be upheld.
And so we don't have a date yet because now that both sides have filed, you will go back before the judge and he will make a ruling on this, correct?
So there's actually nothing that I'm aware of in the rules that says we have to have a hearing. So
Okay.
sometimes this is pretty typical in every jury verdict case, the defense files a motion to set aside the verdict.
Mhm.
Sometimes the state doesn't even file a response. But usually what will happen is the judge will sign an order denying that. There are cases where they've granted it, of course.
Yeah.
But I don't believe there's any requirement that there be a hearing. So I don't know what Judge Arthur will decide to do,
Mhm.
whether he will sign an order one way or the other, or whether he will set it for hearing. But as of now, no hearing date has been set.
No hearing date. So now we know what to be looking for, what to
Mhm.
watch for.
Mhm.
Is he going to, are you going to call y'all back in?
Yeah.
I want to bring
Why
up
is
and
that
talk
funny?
about real quick.
That's what you judges do. They call you back in. You go back in for a hearing. It's not funny. She's showing absolutely zero empathy for this victim, for the defendant, even for Ashley, the victim, but also for CARLY, the defendant. Zero empathy. And what blows my mind is that the first thing she said is that she worked before she was handling murders cases. She was working in the crimes against children. She was prosecuting people for crimes against children. So there must be an empathetic bone in her body for children somewhere. But laughing throughout the course of this interview, like this is ha ha funny. We locked her up for life. We did great. We did great. The world is so much safer now. It's just such a bad look.
The
Thanks, Radine.
Brady violation or Brady
Yeah.
violation.
The allegation. Of a
Allegation.
Brady,
There
yeah,
we go.
yeah,
There
of
we
a
go. That's
Brady
better.
violation.
So tell me how you felt in that moment. I just want to know your true feelings in that moment.
I've never been more mad in the courtroom, and I've malpracticed for 15 years. I have done chancery work. I have done, so that's divorces and those get contentious. I have done civil work, represented people in car wrecks, represented nursing homes. I have been a criminal defense attorney for a number of years. In fact, I was a public defender in Rankin County before I started this job. I have never been so mad. And the reason for that is that the defense was given every opportunity to correct that allegation to begin with. So there were allegations by one of the defense attorneys against myself personally early on.
Mhm.
And so I started documenting everything via email. Said, "Oh, all right,
I
fine."
think you've done this before or something.
Yeah. So I started documenting everything by email. We make them sign saying that they've received everything. And so mistakes happen, right? But with a Brady violation, you're saying that basically I intentionally withheld exculpatory information. So something that is going to show that the defendant did not commit these crimes and or something about an important witness that we had. Like if I put you on the stand and you talked about how credible you are, and then I knew that you had been charged with perjury 10 times and I didn't disclose that, right?
Right.
That's an actual potential Brady violation, something that actually would change the course of the trial, would change the way it was going. So first of all, the messages that they said they didn't have were not exculpatory. In fact, they indicated more guilt
Right.
and said that
Even Judge Arthur said that it perjures their witness and perjures CARLY.
Yes.
Yeah.
Yes. So first of all, you have to show that it's exculpatory or that it was intentional. So prior to we were on a break and we come back and the defense attorney's holding these messages and waving them around. most attorneys would have come up to us before the break ended and said, "Hey, while I was at lunch, I found this.
Mhm.
Can you show me where this was produced?" And we would have said, "Judge, will you hold the jury back? Give us 15, 20 minutes. Let us go upstairs, show them where we gave them this." And then it would have been done.
Yeah.
But that's not how it was handled. Of course, on national television now, they stand up. We didn't get these messages. They withheld them. So I had never been more mad, because that is an attack on me personally and could affect my entire career
Mhm.
and my integrity. That's all I have in this profession. And also, we knew that we had turned it over. And so what you didn't see in the hearing was that before Judge Arthur came back in, his court reporter was sitting there, and I had shown Miss Todd and Kevin Camp where the information was on the external hard drive that we had provided them a copy of. And I said, "Well, would you like me to tell Molly to get Judge Arthur and tell him you want to withdraw your motion?" And they said no.
Oh.
Yeah. Miss Bridget Todd doubled down and said, "No, I want to see it on mine." And I said, "Okay." And she said, "Well, we don't have this particular phone extraction." And I said, "Yes, you do." And so I showed her on her computer, "Get out of that folder, get out of that folder. No, you're just looking at the screenshots. No, it's actually in this folder where it says phone." And then she opened it up. And then, of course, you kind of see that play out where Michael Smith, once it opens up in Cellbrite, Michael Smith shows her where that exact word and messages were, in fact, included in the discovery
Yeah.
that they had received on June the 4th.
It is. It does. It brings up the questions. It makes you want to ask the questions. If you're not, you want to be as ethical as possible, so that there is never anything that can point back to you being unethical and not doing your job right. An appeal could happen, things such as that.
Yeah.
And so it makes me question why double down?
Yeah.
Why?
Yeah.
It just it could not bear well for you going forward. And so I don't understand it. I don't understand it.
Me neither,
You
Karen.
know why? Because Bridget Todd was really mad too. That's why. And we discussed this. If it actually had been a Brady violation, it would have been a big problem. The amount of discovery that you dumped on them, and you gave them like the entire extractions of these kids' cell phones for like years and years and years. You know how much kids use their phones. And the reason it was brought to Bridget Todd's attention, I think, is because one of the minors brought her attention to it.
Again, we gave them the opportunity to withdraw the motion,
Mhm.
and then to continue on, that part to me was shocking. And,
Yes.
and I've said this once before, and I probably shouldn't say it because it's sort of mocking their defense. But I said, like, I was disassociated at that moment. I truly was so
Oh.
mad that I did not know or remember what I had said.
Oh, see, now you understand what disassociation is, because when we observed you on TV, you looked like you were perfectly fine. You looked like you knew what was going on. So are you saying now that disassociative episodes look totally normal to the outside observer? That's really interesting. Let's hear that again.
Shocking. And,
Yes.
and I've said this once before, and I probably shouldn't say it because it's sort of mocking their defense. But I said, like, I was disassociated at that moment. I truly was so mad that I did not know or remember what I had said.
Mhm. I remember. I remember. But no, I think, and I'm not trying to say that they are unethical either, by what I said earlier.
Sure.
I'm not saying that, and I'm not saying discounting them being good, ethical attorneys. So I'm just saying maybe there were some things in this case that could have been done differently.
Yeah, and look, I will say this. I look back on every case that I've been a part of, whether it's the defense side or prosecution, and I think, oh, well, I probably could have said this, or I could have done this differently. And so that's why I said no case is perfect.
Mhm.
I hope that they got caught up in the moment,
Yeah.
and thought that
And
they
that
were
happens.
yes,
It
and
happens.
thought that they were zealously fighting for their client.
Mhm.
That to me, there's a difference in being untruthful and unethical, and you can still fight zealously within the rules.
Yeah.
But again, I'm hoping that was a mistake that they will learn from,
Yes.
and that won't happen again. And hey, anybody watching, if you think I hadn't turned something over, just ask.
Just ask.
Yeah.
So now we're waiting on Judge Arthur to do whatever he is going to do. After that, do you expect them to file an appeal? And at that point, are you out of it?
Yeah, so they'll have 30 days from any order that denies their motion for new trial or J&OV to appeal to the Court of Appeals / Supreme Court. They will file their notice of appeal, and then they kind of file their issues, and then the court reporter has a certain amount of time to get the record prepared. So the last thing that our office does is just kind of go in and make sure that the record that's being sent from the court to the appellate courts is proper, right? That
Mhm.
everything that they ask to be included is included. And yeah, then it goes over to the Attorney General's office. They have an appellate division there who is fabulous, and they will handle whatever the appeal is. Of course, they can call us and ask us questions, but really and truly that's what they do.
Mhm. And
Um,
so are you hoping that are you ready to be out of the limelight? Let me ask you that.
yes. I would like to go back to just trying my cases and nobody knowing who I am.
Yeah.
I
I don't know if that's going to happen for you,
yeah.
but because you did, I mean, you did a great job in this, and just not let's take away what it was, but the fight that you put, it was good. You know, the going to court and watching you, and it was very professional. I wish.
The fight was good. The fight was good. Like, this is entertainment for us. Like, the fight was good. It was like, 10 rounds with Tyson. Like, the fight was good. Really? We're talking about a child's life and her mother's life, and the fact that her mother's entire family was on her side because they know this is not who she is, that something went wrong. But
You know, the going to court and watching you, and it was very professional. I'm sure everybody wishes it's something that would have never happened.
Yes.
You know, I wish that Ashley was still here. I wish that CARLY was still the innocent 15-year-old at home making poor choices that everybody.
But according to you, she was never an innocent 15-year-old, according to the defense. Well, I mean, the prosecution. Hang on. Let me hear what she says about the fight.
Are you ready to be out of the limelight? Let me ask you that.
Yes. I would like to go back to just trying my cases and nobody knowing who I am.
Yeah.
And
I don't know if that's going to happen for you, but because you did, I mean, you did a great job in this, and just not let's take away what it was, but the fight that you put, it was good. You know, the going to court and watching you, and it
The
was
fight
very
was good.
professional. I'm sure everybody wishes it's something that would have never happened.
yes.
You know, I wish that Ashley was still here. I wish that CARLY was still the innocent 15-year-old at home making poor choices that every teenager makes growing up. Maybe not to the extent
That's
of
right.
others.
That's right. So
Um,
sneaking out, vape pens, burner phones, those can all be chalked up as normal teenage behavior.
Right.
You know, grabbing a loaded weapon and shooting at not one but two people, certainly not normal teenage behavior.
Not at all. Not at all, which is another reason why I went home and hugged my kids.
Yes.
I love you.
Yes.
Please, I love you so much. Okay, so I really appreciate you coming. I want to check out our stream real quick and see if we got any
See if
questions.
any of our
You know,
70
in the state
people
of
have a question.
Mississippi, when that happened, and but in the state of Mississippi, she was charged as an adult, so her age really
That's
doesn't
right.
matter.
Her chronological age, as long as it's over the age of 13, does not matter. In the eyes of the law, it's the same as if she were 18 or 38 or 48.
Ridiculous.
Exactly. All right, let's see. Looking here,
15 minutes of fame. We're almost up.
somebody has a
Time
question,
is
a
it?
comment about Bridget Todd, but I'm not going to bring it up. I'm not
Oh,
going to.
how nice of you not to denigrate Bridget
Here's a
Todd
good
on your
question.
stream.
Why was the jury the one who's sentenced and not the judge?
So that's actually the new law, says that for a juvenile tried as an adult and convicted of murder, in order to affix a life sentence, it has to be done by the jury. And so Judge Arthur could not have sentenced her to life. It had
That
to come
is
from a jury.
ridiculous.
And
I mean, you want to let the jury decide guilt or not guilt, or insanity defense or no insanity defense. That is one thing. But allowing a jury to now affix a sentence to this, that is even doubly insane, in my opinion, for a child.
the same thing for an attempted murder. And that's regardless of whether it's a juvenile charged as an adult or if it's an adult. It's life if affixed by a jury.
A
And
juvenile
so
charged as a juvenile would not get a jury. The case would be only the judge. There would be no jury. So,
um, That's why the jury handled it. Now, Judge Arthur did provide the sentence for the tampering with physical evidence instead of the jury doing that. And that's just because the law says that the court shall determine that sentence.
So when Kevin Camp was asking the jury to then put it in the hands of the judge, why was he asking them to do that?
Because the judge could only give her up to 40 years.
Gotcha.
And to be clear,
and that's what she was offered, right?
Right. So we offered 40 years initially. And then I think it was the week before trial, we had a pretrial conference. It's usually about the week before. And Judge Arthur kind of pulls us all in the room and he says, both sides, if this can be resolved, don't be stiff-necked. What can you do? And so we extended our 40-year offer again, and then extended another offer that said we would let her plead open to the murder and the attempted murder, and let Judge Arthur determine her sentence. And they opted not to have that done, not to plead guilty, and rather to go to trial. As we've all seen, Ms. Todd had promised an acquittal. And so, at that point, 40 years is a long time. We're not pretending that it's not. And, a lot of people talk about how could you do that to a child? What we're looking at is not a 15-year-old. We're looking at the heinous nature of the crime and how dangerous this person is. If she were to be released, if she kills her own mother over a vape pen, what else would she be capable of?
Exactly,
Right.
which is why that's
Right,
not
and
what it
then-
was about. That is why that it was not what it was about, because that would never happen if a person was sane, right? This is so backwards. The fangirling by the interviewer is gross, said Bentley.
She would be here in our community, and it is scary to think. Will she get any help? Will she
scary to
have access to help in the prison system, mental health?
Yeah, so she is in the juvenile portion out at CMCF, Central Mississippi Correctional Facility, and they offer mental as well as psychological help for anybody that needs it. And so whatever treatment she needs, she can get there. And then, of course, once she turns 18 and goes into the adult facility, those services can continue.
So she is not with the adults right now. She will stay in the division she's in until she legally reaches 18.
That's right. So any child that's been either pled guilty as an adult or tried and convicted as an adult has to maintain separate from the adult population. So it's a completely different building out at Central Mississippi Correctional Facility where they house juvenile offenders.
But she's no longer in solitary confinement.
No, that's right. And the reason she was in solitary is, thank goodness, Rankin County did not have another violent female juvenile offender. So if there had been another child under the age of 18 that was female, they would have been housed together in the same cell. She was so it wasn't like she was purposely kept by herself. It was just that, thank goodness, there was not another one there.
Okay. I didn't realize that. I knew that she was in solitary confinement, but I thought there was a bigger reason behind it. So it's just simply because there was no
other juvenile. So she has to be kept sight and sound away from the adult offenders while they're in the county jail.
Mhm.
So that's why she was kept away from all other inmates. But yeah, had there been another, in fact, there were a couple of male juveniles that were bunking together because they were, both under the age of 18.
So you say she was kept away. Was there ever a time that she was with them, with the
adult offenders?
The adults?
No.
Because there was reports, or at least Kevin Gregg said that when CARLY called him, that she was talking about they were calling her names, they were harassing her, they were being mean, for lack of a better word. But but she wasn't around them. So how could that have?
She was not supposed to be around any adult offenders. I think that allegation came out at one of her prior hearings, and the defense attorney said that it had been addressed.
Yes,
I don't know the
Mhm.
merits of that. That's not something that we actually get involved in, right? That's the sheriff's department in the jail that handles that.
Right.
But
No
federal
visitors.
guidelines require that juvenile offenders being held as adults be kept separate, sight and sound, away from all adult offenders. And that is for their own protection. And so, she was in isolation, but she had an iPad where she could communicate with people.
Mhm.
She could get out each day, take a shower, make phone calls, in fact,
No
I know that
visitors.
she was allowed visitors, and our jail actually doesn't do in-person visitors since COVID hit. But she was allowed visits after each hearing with her family as
Mhm.
well.
That's good. That is good. Well, and I'm glad to know that she will be able to get help. Because while she may not have fit the definition of legal insanity, we know she has issues. She needs that help. She needs to see someone. She needs to be taken care of with mental health wise.
That's right, Garrett. And I think that can be said for a lot of our inmates, right? That there's some
Mhm.
sort of mental health issue that they need help with. A lot of times it's coupled with substance abuse too, and they offer services for both. But hopefully, yeah, she will get the help that she needs.
Awesome. Well, I know that you have
Awesome.
got to go back to work to some of the not as looked at cases.
Yeah. I doubt the national media will cover my next trial.
Hopefully they don't.
Yeah.
Hopefully they don't. Well, guys, thank you so much for tuning in for WLBT Plus today. Thank you, Catherine, for coming in and speaking with us. We are definitely going to continue to follow this, and we'll let you know as soon as we hear something from a Judge Arthur, whether he calls him back into the courtroom or just says, nope, we're not going to do this.
Well, bless
We'll
your
let you know.
heart,
Thank you again for
ma'am.
tuning in. I'll be back tomorrow at 1:00
Bless
for
your
WLBT
heart.
Plus. You guys have a great day. Bye-bye.
Y'all have a great day, because we're all having a great day here. Bless your heart, ma'am, says Yuri's math teacher. I need a shower after that. I need a shower. Kimmy, thank you from Canada. He threw his daughter under the bus, not answering, said about Kevin Gregg. Thank you, Wendy, darling, so much for your 5. I appreciate you, darling, so very much. I'm so happy to see you today. Bodine62, thanks for the 20. The injustices we are seeing in the court system lately is appalling. No way it has just started. I'm sure it's been going on forever. The amount of injustices over the years before spotlights from social media is terrifying. Yes, I agree with you. I'm here to shine a light on it, which is why a lot of my streams get stricken, which is why a lot of times YouTube algorithms don't like me talking about certain topics, but I'm not going to shut up about it. So we're here for it. We're shining a light on this. And thank you for being here with me through all of it. Terrifying. Sorry for the typo. Don't apologize. Thank you so much. Sophia, thank you for your time. Thank you for your time today, Sophia, for coming here and spending your day with me. Thank you so very much. And for the 10. And for Mike, Midnight Mike gifted a membership. So congratulations to the lucky recipient of that. Sherilyn, thank you so much for your Cash App, who says that this prosecutor is a disgrace. And also to Justin, who sent a Cash App and said, good luck to CARLY. I think what I need to do next, if she's willing, is have Bridget Todd on to refute everything that we just listened to. Let me know if you'd be interested in that, if she's willing to do that. Thank you, Joyce, so much for your super sticker. I appreciate you so very much. Each and every one of you who chooses to spend your time with me, you are amazing. Phoebe Mick says, wow, the defense in Delphi just stated that the hair in the victim's hand does not match Richard Allen's DNA. Never before made public. They're doing this. They said this during jury selection, or they did an interview, or what, Phoebe? Well, that's some exculpatory, wouldn't you say? Monique, I'm sorry, Monica. Monique was earlier. Monica said possibly CARLY showed no emotions during court is probably because she had no idea what was going on or what was being said. I'm guessing she was in protective mode. Yes. Or she's also on the highest dosage of Abilify, which is an antipsychotic that they give to schizophrenics. She's on the highest adult dose of Abilify. So if anybody knows anything about Abilify, if anybody is on Abilify or has a family member on Abilify, please let us know if there are any side effects, if it affects your mood, demeanor, the way you present, because I'm curious to know that. And perhaps that has a lot to do with her affect as well. Andy, hi, Andy. Am I missing something? Did this prosecutor just spend 10 minutes saying CARLY was of sound mind and then spend 5 minutes saying she will get treatment for mental health issues in prison? Yes, yes, yes. Oh, yes, oh, yes, oh, yes. That is exactly what you heard. Karen says more, Miss Todd, please. Yes, they had just increased her meds. That is so true. You guys would love to see Bridget come back to refute this, and I would love to have her. Please, if you are able or willing or even have any interest at all, the appeal fund that is set up for CARLY is linked below in the video description. You can go there and you can donate $3, $5, $1. And her grandfather will write you a personal thank you note. That's how invested the grandparents are in this. Thank you, Dr. Berry. Abilify is also for bipolar to help stabilize mood. I guess my question is, does it make, like, I've seen people on lithium before, on high doses of lithium, and it does make some people look completely zombie-like. almost droolish or drooling, and almost like they have completely flat affect and are unable to react to anything. I'm just worrying, wondering, that is, if Abilify causes the same type of, that's why she looked that way in court, I guess, is what I'm getting at. It's at $9,600, Sherilyn. Thank you so very much. I appreciate that. Sophia said, I had a friend in the VA on Abilify and she had a flat affect, but it does affect people differently. We have 1,100 in chat right now. We were up to something like 1,200 at one point. Please, please, please hit the like button. Share the stream out for people that you know that need to see this. I am going on with the glare tonight at, I think it's at 6 p.m. Hold on, let me just check. 6 p.m. I'm going to go on the Glare's channel. So I'm going to redirect you over there so that you can like hit the bell and come back and check us out later. It's going to be on his channel tonight. And we would love to see you there. I'm not sure what we're going to talk about. I think we're going to talk about Karen Reed and all the new stuff that's happening on Karen Reed. And we would love to see you there. So come on over. I'm going to redirect you there so you can hit the bell and come back later and spend some more time with me and Will. Just set up that redirect. There's that. Teleportation is such a lovely thing, isn't it? Smash the like button. Maybe we can take calls. Maybe we can. I think he's got a burner phone. I think so. Love the Mill and Will show. Thank you, moderators, for keeping the chat classy tonight. You're amazing. I know this is a hard case. There's so many strong opinions about this case on both sides. And super quick meme email says, Jason, hold on. I mean, that's hilarious, but I'm not going to show it because I will not denigrate that attorney. Even give her any more. Yes. Oh, yes. Oh, yes. Let's see. She's mom. I've been on lithium since I was 9. Give it a few years, in my 50s now. Best thing that ever happened to me. Okay. Okay. Thanks, Jason. But I can't show it. Maybe you can publish that one on your own. Thanks for supporting the channel. Rebecca Davis, I'm on Abilify. It has been a great med for me. It stopped all the racing thoughts and out of control anger. It also helped me sleep better. No more insomnia. Other meds had horrible side effects. That's good to know. It's good to know. But maybe because she had just been on it for a little while, that's why we saw she had sort of a flat affect in court. And she's a child. Thank you for keeping me eyes sane too. You guys really, you do help. All right. Be cool, be kind, be classy. It is so not hard. Smash the like on your way out. Feel free to share the stream out for those of us, those people that you know that need to see this. And safe travels over to Glara's channel. Hit the like or whatever, the bell, the notification bell, so that you come back and see us at 6. I need to go take a break, maybe a nap. I'll see you guys later. Peace.